Fine, I see everyone's ready to proceed, and I see Professor Stefczak is online. It's a little weird having no one there, but do I look into this camera, I suppose? Yeah. Good. Uh, is there anything to be raised before we start with the examination?
Nothing from the claimant side, Mr. President.
Nothing, Madam President.
Good, then we can start. Good morning, sir. Do you hear me well? That is, do you hear the interpreter?
Good morning.
Yes, greetings. We can hear you very well.
So, thanks for being with us this morning. You're Marek Stefczak.
Yes, indeed, I confirm.
You're a professor of civil law at the Comenius University in Bratislava.
Yes, that is correct.
And you're currently director of the university.
Yes,
You provided us with two written expert opinions. The first one of the 30th of September 2022 and the second one of the 15th of September 2023. Do you have your opinions with you?
yes, I have them both with me.
And they are in clean annotated, unannotated copies.
Yes, I have a printed copies.
Not on your copies.
No, please have a look.
Are you sitting alone in the room? He has two people. He has two
Yeah.
people in the room.
Yes.
No, I'm here with two of my colleagues, one lady and one gentleman colleagues.
And this is agreed like this? Yes.
Madam President, it is.
I think this is how it has been agreed.
It is agreed, Madam President, but I would kindly ask the gentleman sitting to the left of Professor Stefczak to go further
Good.
away a little bit.
Yeah, because he's in can you please move somewhat away from the witness?
Of course. I'll do it.
Can you, good, can we have the names of the people who are there? Or do we have on the participant list? I don't think so.
And I'm on behalf of all.
Fine. Can the other person please introduce herself? Thank you. I think we, for the interpreters, I'm just mentioning that we've have it on the recording, so I think that is enough, and I see council nodding, so we can proceed. Professor, you are heard as an expert. As an expert, you are to make only such statements that are in accordance with your sincere belief. Can you please confirm that this is what you will do by reading the expert declaration that you should have there in front of you. You do, yes, absolutely.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
So now we can proceed. You will first be asked questions by claimants counsel, and then we will turn to respondents counsel. Mr. Tashikamp?
Thank you, Madam President. Professor Stevchek, do you see me on the screen in front of you?
Yes, yes. Well, specifically not you, Mark, I'm afraid.
Well, you can hear me, as I understand, is that right?
I can hear you, yes.
Can I step in because I forgot to mention something before. Professor, you can confirm to us that you have no other communication channels open than the one on which we communicate now, which is the Zoom video link, and one, possibly one screen where you will be shown documents. Is that right?
Yes, I confirm there is no other communication channel that I would have.
Is your phone into flight mode?
Yes, I do.
Thank you. Apologies for the interruption.
Thank you, Madam President. No problem at all. Professor Stevchek, I understand that you wish to make a few corrections, minor corrections to the English translations of your two expert reports. Is that right?
Je to tak?
Yes, Margie, indeed, that is so. There were two terms not well understood in the translation. So I would like to change that to the term public special purpose road. Everywhere there has been in my expert report mentioned, and there is the paragraph 5.1. There was a wrong translation, merits. Instead, it is supposed to be jurisdiction.
You have been handed a list of the corrections, and I assume Respondents' Council has as well.
Indeed, Madam President. So with your leave, we would invite that document to be added to the record. We can, of course, assign a number to it after
Thank
the
you.
examination. Professor Stevchek, are there any other corrections that you would like to make to your expert reports apart from the corrections listed in this document?
No, none.
Thank you. Would you please now answer any questions that Mr. Pekash has?
Before Mr. Pekash starts, I would like to ask that whenever we are not asking questions about a specific document, we see the screen was the witness, and here we see the witness statements. Can you remove the witness statements and make sure that we see the witness in on a large screen? Who controls this?
You should have heard that, so I'll tell him. Yes, it would be helpful if you could see the.
This is too small.
You can see the witness in the big screens.
Yeah, over there, it's very far and not there.
That's 30-year-old eyes make a difference. This is still off the record, Mr. Tushingham. I'd be grateful if you could file this errata electronically as well.
Yes, we will, of course, arrange for an electronic version of that document to be circulated.
Thank you.
Thank you, that's much better.
Thanks, Farah.
To Mr. Pekash.
Correct. Then the screen will have to be shared.
Thank you, Madam President. Good morning, Professor Štievček.
Dobrý.
Good morning.
Professor Štievček, my name is Rostislav Pekač. I'm counsel for the Slovak Republic. And I will ask you a few questions this morning regarding your two witness statements. Because we are on transcript and because we are only connected by video, I would kindly ask you to answer in an audible manner to any of my questions so that you have it on the transcript and so that I can hear the interpretation of that answer that I'm working on.
I will do my best.
Thank you, Professor Štievček. My first questions will actually relate to the corrections of your expert reports. Do the corrections come from your personal review of the English version of your English report of your reports?
To put things in the right perspective, there were multiple versions of over the time of my expert report, which is quite, I suppose, normal and understandable. Each one version was then translated. I don't know whether it has been the same person every time a new translation was made out, or there were several persons, in fact. In any event, yes, I have identified two specific terms with which I was not satisfied the way they were translated. The first one, merits as opposed to jurisdiction, I think is only a translation error because from the context, I in Slovak never mentioned the word merit. Perhaps act or substance of act. In my Slovak version of the report has always been the word jurisdiction. With regard to the second term, that's the public special purpose road. Of course, in English, there could be multiple equivalents in English. How to translate this into English? And I think that the term public special purpose road covers all content of the term by which the legislator had in mind when enacting in legislation the very term of public special purpose road.
Thank you, Professor Štievček. So you agree that public special purpose road is the best translation of the Slovak original term, correct?
I dare to say yes. I'm convinced, due to what I've just said before, that it really covers all substantial signs of content. One is special purpose that is supposed to serve a certain purpose. And that next one is being public, so it's publicly accessible.
Professor Štievček, I would ask you to look at paragraph 11.5 of your first expert report in both English and Slovak, please.
So I'm at liberty to view my report, right?
And I would like to ask you to view both the English and the Slovak version, and I believe it would be helpful now to have these two versions on the screen as well. Would you agree with me, sir,
Budete so mnou súhlasiť, keď poviem,
that they are two sentences in the English version which span over almost 3 lines, while there is only one sentence in the Slovak original, correct?
Áno,
yes. But if I may add, in English, the first sentence only mentions the merit of the fact, saying that the Madame Marianova had filed an appeal. The second sentence says the appeal was struck out, and I don't know why there is only the second sentence in the English version saying that, in the Slovak version rather, that the appeal has been struck out. I don't know how to justify this being this discrepancy between the two language versions.
Now I would ask you to please turn to paragraph 32 of your second expert report. And again, it would be helpful to have both language versions in front of us on the screen. So in paragraph 32, you are quoting Article 120, paragraph 1 of the Code of Civil Procedure. Is that correct?
áno.
Yes.
Could you please read out loud in Slovak so that it can be interpreted by the interpreters we have here, the quote from paragraph 120 in the Slovak original? And I would ask the members of the tribunal to compare that to the translation we have in the English version as they list.
Yes, I can. The parties are obliged to mark evidence to substantiate their claims. The court shall decide which of the marked evidence will be enforced. The court may also execute other evidence than those proposed by the parties if the proceedings is necessary to make a decision on merits.
Professor Stilček, I apologize. I would ask you to read the last sentence again, because there's one important Slovak word which was missed on the interpretation, and this is no criticism on the interpreters. I understand it's not easy. So please read just the last sentence again.
The court may exceptionally also take evidence other than that proposed by the parties if its taking is necessary to decide the case.
Professor, thank you very much, Professor Stilček. I understand that you understand written English, correct?
Yes.
Would you agree with me that the sentence that you can see in bold in the English version is completely different from the last sentence of the Slovak original?
If I may, I'll take a minute to read it.
Ja bih
Yes, but I'd like to emphasize, of course, it was not me making the translation into English.
Yes, Professor Stevchik, and I did not mean to suggest that you were. I would just ask you to confirm that the English version, which says the court shall be under an obligation to take additional evidence, is, I would say, diametrally opposed to the Slovak version, which says that exceptionally it may take other evidence, correct?
Yes, I confirm that. The sentence or the law is formulated as option, which I consider completely logical because it is up to the court to consider whether or not the proposed evidence or even evidence not proposed by parties will be taken into consideration or not. It's up to the discretion of the court, while in the English version indicates an obligation imposed to the court. Once again, allow me to emphasize, it is not my responsibility for the English translation.
Professor, pardon me, is the remainder of the bolded sentence in English correct? In other words, the court may exceptionally take evidence when such evidence is necessary to establish the facts? Is that part correct?
to
I would translate the phrase establish the facts in proceedings differently.
And how would you translate that personally? Yourself, I mean?
I guess off the top of my head, this as though it indicates that establish the facts, which doesn't necessarily have to be an issue of fact, because the law says about the importance of the decision on the merits. But I would not dare now to give you an exact translation right away.
Well, thank you, sir.
Well, maybe just to one last point, Professor Stevchik, would you agree with me that there's an adjective which was translated as necessary? In Slovak, it's nevyhnutné. Would you agree with me that the best translation would be something like unavoidable?
áno,
Yes, I guess so.
Yeah, thank you. Now, Professor Stevchik, I would ask you to turn to paragraph 28 of your first expert report. And for the record, this is one of the paragraphs which is subject to the errata sheet submitted this morning. Which saves me 2 questions. So thank you very much for these corrections, Professor Stevchik. Please let me know when you've had a chance to read the corrected English version of 28.
mám.
Thank you very much. So
I have it.
when you say, Professor Stevchik, in the correction sheet that it's supposed to be public special purpose road, you refer to Article 1 to D of the Road Act, correct? And just we will have a brief look at it. It is Exhibit R 175. And what we can see in Article 1.2 is that surface roads are divided according to traffic significance, destination, and technical equipment on A, state highways, B, state roads, C, municipal roads, D, special purpose roads. So we are in agreement that what you mean in paragraph 28 is special purpose road within the meaning of Article 1, 2D of the Road Act, correct?
Áno.
Yes.
So now going back to paragraph 28 of your report, of your first report, you stated there that the character of the field track in Smilno as a public special purpose road stems from Exhibit C18, correct?
Áno.
Yes, correct.
So can we please have Exhibit C18 on the screen? So please, Professor Stevchik, review the document and let me know when you have a chance to review the document.
Tu,
It's quite illegible, or I'm not seeing entirely the Slovak version because of the split screens. Do you want me to focus on the English text instead?
I'll see if we can maybe enlarge the Slovak version a little bit. Is it better now?
Because there is an overlap part where I see the video images of the court in session.
We can remove the English for now, so the witness can see better the Slovak. Is that better, sir?
It's better, thank you. A little smaller, if I may. Smaller, rather.
For the room, I think the issue may be that he has a smaller screen. As a result, he doesn't see things which we have on the right side. So if the Slovak original goes on the left side and the English translation on the right side, he will be able to see the Slovak version, and we here on broader screens will be able.
I think it's the gallery viewing on the Zoom at his end.
Yeah.
Because he's got the participants showing on the
Yeah.
right-hand side, because I've got a similar laptop.
Yeah, but can you see things which are on the left? Well, so in other words, it cuts on the right side of your screen,
Exactly.
right? Yeah, okay.
exactly. But he can alter that side.
No, but it is fine. We can just switch the language.
I confirm that I can see that now.
Okay, thank you very much. And apologies for the technical issues we were resolving here. Now, later in these proceedings, we filed another translation of this document under exhibit number R156. So now I would ask that R156 be displayed on the screen. And I would like you, Professor Stevchik, then to confirm that this is indeed the same Slovak original, C18 and R156.
I can only see the Slovak version. It's the Smilno municipality request, and I see a part of English translation. However, I'm unable to confirm what translation that is, whether I have ever seen it before. That's something I cannot tell you now.
No, I was, Professor Stevchik, apologies, I probably misspoke. I was just asking you to confirm the Slovak origin. That the Slovak original is the same as the one you have under C18 and the same as the one you referred to in paragraph 28.
So I understand, confirm it is identical text.
Okay, so Professor Stepchek, you confirm that this document in the Slovak original refers to field road or field track, correct?
Field road, yes, it is written there expressis verbis.
It does not refer to public, or it does not use the words special, public special purpose road, correct?
Understandably, it is not there. I've been explaining that, I think, in my second report. It's difficult to expect of municipal office of a small village to reflect all legal terms. Basically, that's unthinkable. I think we've every one of our lawyers have encountered this, that a lay public simply is not using legal terminology. However, in terms of logical semantics, every term has certain term features. The essential and negoti is called the in legal theory. Now, when various certificates issued by the Smilno municipality declare clearly that road has been used by the public as number one, I dare say it is the same that that is a public road. And if it is claimed clearly that it's been used as field road, specifically as a connector and access road to mines, to mine quartz, that simply is the same term feature used by the legislator to establish the special purpose of a communication, meaning road. That is why I deduced a conclusion that this document, even though it's not does not feature legal terms and features, however, descriptively refers to all the term features, and in my opinion, one can conclude without any reasonable doubt that this is a public special purpose road. The normative text itself states, if I remember correctly, specifically the mine as one exemplary calculations of what is the purpose of any special purpose road. So to me, the term features have been met. And I repeat, we cannot expect, I think it was Mr. Mayor or who signed the letter, who I expect does not have legal education. We may not expect them to be using legal terminology and definitions.
Just to summarize, and this is a simple yes or no question, sir. On the basis of this document alone, you are able to conclude beyond reasonable doubt that the road is a public special purpose road, correct?
Yes, I dare to make this conclusion.
Yes. And now, if the letter is addressed to someone who, unlike you, knows the actual condition of the road, and for example, that person knows that the mine had been closed for 70 years, would that change your assessment, sir?
No, because in that certificate or letter, there is a present continuous tense used, is being used. So it continues to be used by the public for decades or maybe centuries. If the Smilno municipality wanted to say that this has been sometime in the past, I expect they would use past tense. In that letter, it says clearly is being used for decades, 100 to 200 years in parentheses. I understandably am not familiar with the local conditions. I've never physically been in that municipality or on that road. And I can only base my conclusions on what I was given. Meaning, from these arguments, I deduce my claim that this continues to be a publicly used road, special purpose road. Thus, public special purpose road, as the witness put in English.
Professor Stepchak, I would kindly ask you to focus on the specific manner how I formulate my questions. My question was, I was asking you to take into consideration the fact that the letter is addressed to a person which, unlike you, was aware of the actual condition of the road. And for example, and you can take that as hypothetical. So hypothetically, if that person was aware that the mine had been closed for 70 years, would that change your very strong opinion you have of this letter?
No,
Would it change your opinion if hypothetically the mine had been using the road on the basis of a lease agreement it had with the then owners of the road?
no. Due to a simple reason. I judge the text. Council is trying to add something into the text, which is simply not present in the text. In terms of grammar, in its interpretation of the text, it says clearly that which I've already mentioned. And I'm not sure about these additive hypotheses, how to take them into consideration. I did not have them at my disposal when writing the report. Even now, when Mr. Counsel is declaring them, this has no bearing on the meaning of the text. I repeat, this is not a decision issued in an administrative proceedings because no such thing exists. No one has ever requested such decision. It is a confirmation by the Smilno municipality. Basically, I'll tell you frankly, I don't care to whom it's been addressed because the text is so straightforward. There are no additive hypotheses that are going to change my opinion.
Can I ask you for a clarification? When you wrote your reports, did you have the letter requesting the advice of the mayor?
Yes, I surely had it at my disposal. However, I don't know if it was right from the start, because I did mention that there were multiple versions in time of my report. But yes, when finalizing my report, I was basing my report on this submitted evidence letter.
Would it change your opinion if I remind you that the request specifically used the term public special purpose road?
I'm not sure I understand the question. if I try to reformulate the question, if I may. Meaning, if there was mentioned in the letter the legal term public special purpose road, is it what you're asking about?
The request for the opinion says, please confirm that this is a public special purpose road. Does that change your opinion? Does the fact that the response uses a different term, that is field track, change your opinion?
I understand now. First of all, I think I have not seen this particular request that we are having on the display. The request itself, this is the answer to the request. I've never seen that. Secondly, likely it would not change my opinion.
It's understood you because I understood that just before you answered to me that you had seen the request when you drafted your final version of your expert reports.
I think we are misunderstanding each other. I have seen this respond to the request, what we have on display. I guess I have not seen the actual request itself. By somebody asking municipality Smilno to issue such information. I've only seen this final information respond to the request.
Good, that's clarified now. Now take it from
Okay.
me that the request says, can you please confirm that this road is a public special purpose road? And then the answer is what we have here. Would that change your opinion?
That's the
Once again, I'm going to say no, due to the same reason I've said before. I don't think we should assume with this Milno mayor that he would be aware of legal terms used by legislation. Which means to me, even if to such a specific question, he would formulate this answer we see here, I would equally conclude the same, that yes, indeed, this is a public special purpose road within the meaning of the legislative term.
Thank you, and apologies, Mr. Prakash.
And thank you, Madam President. And Professor Stevček, are you aware of the fact that Mr. Baran is a witness in this arbitration?
Who is Mr. Baran?
Professor Stevček, if we scroll down the document, you will see the signature of the mayor of Smilno. His name is Vladimir Baran. Can you see that, sir?
Yes, I see that. But I have no knowledge of him being a witness in this particular hearing.
So actually, he was heard as a witness on Saturday, and we will show you on screen, and I will read out loud so that you have it translated into Slovak, his answers to questions asked by arbitrator Sands. It starts on page 72, line 1 of the transcript, and ends on page 73, line 4. It is PDF page 22. I will wait for the document to be on the screen, as this will help the interpreters. And No, I was referring to PDF page, not internal pagination. So internal pagination 72, PDF 22. Perfect. So we can see there at 11:25, Professor Sands asked, so you carried out the assessment of how to characterize the field road or the track or the path or the road, whatever it is. Answer, yes. Professor Sands, so you're explicitly asked with the draft response to characterize it as a special purpose road, that characterization, and you don't do that. So you've gone through an intellectual exercise of your own, and you appear to have rejected that characterization and used a different characterization. Could you explain to us your thinking on why you did not follow the suggestion that was put in the draft and instead characterized it as a field track? What was your thinking behind that? Answer, because it's me, I don't need to be, advised or told what to do. And I said it as it was, and it is called by the local people Polna Cesta, which means field road. There are no road signs, so it rules out the possibility of being a special purpose road, in spite of the fact that it has been used for a century, and it's known among all villagers in Smilno that it's a road. But it's the paved works, it's field road. Field road, yes, we call it field road. So would you agree with me, Professor Ściełczak, that the mayor of Smilno was actually aware of the legal term special purpose road?
I would disagree with you because mayor is not a qualified lawyer, and only a qualified lawyer, and even I think only court is authorized to interpret legal terms. Of course, this is the first time I see this. I do not know Mr. Baran, the mayor. I do not know his thinking, but from what you have read to me, it is completely clear to me that legal definitions are not clear to him. Because when I use the term field road, it is a component out of a larger amount entitled public special purpose road. And that's the term used by legislator. So if the mayor is using a field road, so it's a subsum of the public special purpose road. Because in the legal definition, there is a demonstrative enumeration of that which is considered special purpose road. That could be public or non-public, or special purpose road demonstratively named by the legislator also field road. So if the mayor claims it's a field road, he claims it is special purpose road. If he claims it is being used publicly, has been used for decades, he claims it is public special purpose road. This is how I would see this.
But would you agree with me that this is not how the mayor saw it, correct?
I don't consider your question correct because I'm unable to say what the mayor had or did not have in mind when he testified before the tribunal. This is not the right question to be put to me.
Fair enough, sir.
I have a very quick follow-up question on precisely this point. Once again, counsel, you read my mind. Mr. Tushingham's done the same throughout the hearing as well. Sir, could I ask you to enlarge the transcript on the screen? Professor, I've heard everything you've said a moment ago. I just have a very particular question. You'll see that during in the mayor's answer, at one point he says, there are no road signs. So it rules out the possibility of being a special purpose road. Those are the mayor's own words. Do you agree with that analysis? You're the first lawyer, other than the party's counsel in this arbitration, to whom we have the opportunity to put such questions.
I would kindly ask again, because we have the same problem. I only see a part of the text. If it could be put to the left on the screen because of the video windows I have on my screen. Because I do see only up to 3/4 of the text from right to left.
I don't know if that, can that be?
Can minimize his video window. He clicks on the right-hand side of the minimize icon.
Well, I don't want to make it more difficult for the witness.
Not on your.
I'm not sure if I can manage this. I can ask my colleague here in the room. She can do that for me. Is that correct? Is that okay?
Yes.
How many? Just throw the light bulb.
Very well. I can see the right side of the text on the screen. Now, when I'm reading this, there are no road signs, so it rules out of this being special purpose road. Again, I respect Mayor as a person, but obviously he will not be an expert to administrative law. Neither am I. I'm not no administrative law expert. But as far as I know, and I have studied the Road Act and the executive regulation accompanied to that, there is no mention anywhere of any road sign as a feature of this being a special purpose road. I think this interpretation of Mayor is invalid because the Act only says that it connects 2 points either within an area or multiple areas, based on which it is then judged whether or not this is a public road. But it doesn't say anywhere about any road signs needing to be a feature necessary for a special purpose road. I repeat, if I may, once again, the feature points of special purpose road. I'm only a civil lawyer, but I take the liberty of saying that the administrative regulation, the Road Act, has established term features of special purpose road differently, completely, as to what the mayor perceives. I repeat, Mayor obviously is no lawyer, he's no expert, so that is why I would not blame him for not using feature terms as established by the legislator.
I assure you, there's no blame at issue here. I'm simply taking advantage of your own expertise. Thank you. That's very helpful.
Professor Stevchik, let's please look at Article 3 of the Road Act. This is again R175. Subparagraph 2. I will read it out loud. Local state administration in matters of local communications and special purpose communications shall be performed by municipalities on the basis of delegated exercise of state administration. Municipalities shall determine the use of traffic signs and traffic devices on local communications and special purpose communications, and shall permit reserved parking places thereon. Municipalities, as part of the delegated exercise of state administration, deal with misdemeanors under Article 22C in the area of local communications and special purpose communications. Can you see that, sir? I thank you. There's the Slovak version on screen. We just need to roll
She won't give.
down to Article 3.2.
Further down. Yes.
The English version needs to go further down. We are there in the Slovak version. Now we need to. Oh, we don't have, oh, we have it. Yes, perfect. So, Professor Stevček, would you agree with me that the Smilno municipality is actually the state organ that has jurisdiction over special purpose roads in its territory?
Yes, I agree. It is not a state body, but it acts as a transferred power from public administration. Yes.
And it is the municipality which also determines the use of traffic signs and traffic devices on special purpose communications, correct?
Yes.
So if the municipality and Mayor Baran decided not to put a road sign on the field track, would it actually confirm that he did not consider the field track to be a special purpose road?
I think that this shortcut is not quite acceptable because I personally am familiar with many special purpose roads on which municipality never erected any road signs, traffic signs, that is. So from the fact that there is, let's call it a communication, a road as a working term, there are no road signs on this road. To me, logically, one cannot assume the conclusion from that this is not a special purpose road. To put it differently, there are special purpose roads where the municipality has decided to place road signs. And there is a number of special purpose roads municipality has not decided to place any road signs. And I'm quite sure, I dare to declare that there is a number of special purpose roads a municipality is not even aware of its power to do so.
Would you then agree with me that Mr. Baran or the municipality of Smilno being the body of self-government with the delegated state power to exercise administration in the matter of special purpose roads, that body is the best place to answer the question whether a field track in its territory is a special purpose road or not?
I think the municipality is that body which knows best local conditions, is capable of judging them best, but I dare not say whether at the end of the day, the municipality is capable in legal terms to judge what the legislator had in mind when enacting the term public special purpose road, because there is no conclusion from this act or any other that a municipality were to make a decision on about what is and what is not public special purpose road. Municipality only executes administration as a delegated power from state administration. But the fact what is and what is not special purpose road, I dare say, is derived directly ex lege. Municipality merely executes administration over such road, and I do agree that it has the power to potentially place or not to place on such road appropriate road signs. And it also has the power to issue sanctions for violations of the appropriate legislation.
Okay, so let's look at the legislation. Let's scroll up this time to Article 1.3 of the Road Act. It states surface communication consists of the road body and its components. The road body is demarcated the outer edges of ditches, gutters, embankments, and cuts of slopes, frame and cladding walls at the foot of retaining walls and on local roads, half a meter behind raised curbs, sidewalks, or green belts. Can you see that, sir?
Yes.
So would you agree with me that this is a definition of a surface road, or
Yes, this is the legal definition of surface road.
and as we can see in Article 1, a special purpose road is a subset of surface roads, correct?
Yes, special purpose road is a part of the sum of surface roads.
Therefore, the definition which applies to all surface roads also applies to special purpose roads, correct?
Yes. As a general clause, definitely is. However, right in the Article 4, for instance, there you have an exception for special purpose roads. In my view, from those particulars proclaimed by Article 3, or paragraph 3 rather. So by legislator themselves, the special purpose roads are viewed as a specific sub-sum, because in paragraph 4, it enumerates what particulars road must meet. And there is no reference therein to special purpose road. So I deem, if I may, it is because legislator is aware that the special purpose road operation cannot be wedged into a definition. From that point of view, that local conditions must be taken into consideration. To put in other words, one may not expect from every single municipality in Slovakia to have exactly equal mode of operation, because specifics must be taken into account of that given location. And last but not the least, financial considerations as well. I only speculate, because not every municipality would have funding sufficient to be able to build such road as majority of public would expect. That means that I expect your question is leading towards whether the road track may be considered special purpose road. That's when I think yes, because clearly the municipality of Smilno, I have no idea what is their population or budget, but I expect from their own resources, as the administrator of that road cannot afford to build up there something reminding a really something meeting legal definition of surface road. But in other words, if I may, special purpose road is also road track or forest track. Every one of us naturally understand the term field track or forest track. And we have no doubt that either field or forest track or road, even though it's an inductively incorrect conclusion, nowhere in the world obviously is nothing else other than trotted out or driven out stretch of ground on which customarily it is driven, which was confirmed by Smilno itself. This is how I see it, but I repeat, I'm no expert for administrative law, neither for transport or road law. This is a disclaimer I'd like to put on record.
Thank you, Professor Stevček. I would ask you to really focus on the scope of my question. I'm trying to ask questions that are simple. Obviously, if you feel the need to answer more than yes or no, you're welcome to do so, but please focus on the scope of my question. And now, would you agree with me that the legislator in 1.3 speaks of all surface communications, correct?
Yes.
And in that provision, which you agreed is a definition, we see the requirement for a surface communication to have a road body, correct?
Yes, but then I would ask to give me an answer to the question, what is a road body?
Mr. Stevček, we will come to the significance of the road body later on, but
Could I
Yeah,
just
yeah,
come in here? I'm just speaking personally on my own account, not for any other arbitrator, but can I ask the witness this question? Is it not the case that we have here two opinions? We have an opinion from the mayor as to the nature and status of this road. We have an opinion from you, sir, as to the nature and status of this road. There is a difference of opinion. You've indicated that ultimately it's a matter for the courts of Slovakia to form a view. We aren't going to be able to get a clear view on this question in these proceedings. So is it not the case that we're stuck between two opinions, and it is for us as a tribunal to then form a view as to which of those opinions are likely to accord to the views of the courts of Slovakia?
Clearly, I would not formulate it in this way, but I do agree that here exist not even two, I dare to say multiple legal opinions, because the legal modus operandi of special purpose roads in Slovakia is really sort of a field untrodden. It is something no one have ever tackled this issue in sufficient depth, and it is a problem in Slovakia. I completely agree with you. And since we do not have sufficiently evolved doctrine in this area, and nor the case law of our courts provide clear answer to that, I agree with the opinion that this question is disputable. Quite clearly, that is why I think we are debating this by relevant experts here. There are no clear answers to this question, and there are even no clear two opinions. I dare say there are multiple opinions on how to resolve this issue.
So if there are multiple opinions, I'm understanding you, sir, to be saying that there is a multitude of reasonable opinions that go in different directions. Am I correct in understanding you in that way?
Yes, you do understand absolutely correctly. It is one of several questions to which there is no clear legal answer.
Thank you very much.
If I may follow up very quickly on that question, because Professor Sands was not, it turns out, the only arbitrator asking himself that question. You used the word earlier, Professor, ex lege. And so I'd like to ask you, ex lege, which organ of this state, in your opinion, has authority, including it may be a delegated authority, to decide whether a particular communication is or is not a PSPR? And I don't mean the courts. The courts obviously control the actions of the state in certain respects. Which state organ or has authority or delegated authority in the first instance to declare the nature and status of a particular communication?
It's a very good question indeed, and thank you for that. In my best knowledge, there is no such body, in a meaning that there would be a non-existence of a specifically legally proclamated authority of a specific body of public power, which would be authorized to crack this issue. There only exists provision about that the administration of such road is executed by municipality. We do not even have normatively resolved question who is the owner of the road. We know only who's the administrator according to appropriate act that it is municipality, but in terms of civil law, we do not have clearly established who's the owner of such road track. And derived from that clearly is something that I'm not aware of, that in the Competence Act or any other act in Slovakia, there would be a definition of a body having such exclusive authority. Yes, may I add, there exists a general provision in the Competence Act that the interpretation is given by appropriate ministry or appropriate central public administration or state administration body, rather. But this interpretation is expressis verbis legally unbinding. That is stated by every one of ministries when answering any such request for their position. They would, based on the Competence Act, they are obliged to provide their position, even within a deadline. I think it's 30 days. I'm not sure. But every such opinion or position is concluded by words that this interpretation may not be construed as legally binding.
Professor Stelček, would it change your view if I tell you that the road is privately owned?
Madam President, this is a more complicated issue. I don't want to go into detail completely, but there is a difference of owning land, and there's a difference of owning road body placed upon the land, regardless of what the road body is. This results.
Then I put the question differently. Does it make a difference if the road body, assuming there is one, is placed on private land?
No, it would not. I have to say here, as the rector of the largest Slovak university, that we have had a huge amount of problems with this. And I'd like to, if I may complete my explanation, in Slovakia, it does not apply what it does with the rest of the continental Europe from the times of the Roman law, there is the so-called superficial principle, which says that the landowner is automatically the owner of everything placed on that land. This in Slovakia, maybe the only European country, does not apply. So in Slovakia, customarily or frequently, there are different landowners and different owner of anything placed upon such land. And I claim that this is exactly this case here, that the road body, no matter what we imagine it be, is a different legal entity, and it does not automatically belong to the owner of that land.
Are roads that are situated on the territory of a municipality in principle owned by the municipality then?
I'm unable to give you a clear answer.
Fine. I'll stop here, Mr. Pekash.
Thank you, Madam President. Professor Stevček, I think you mentioned several times that ultimately it's for the courts to decide. Do I recall that correctly?
Yes. But again, I have to please add, as you know very well, courts are not capable of concluding a specific question normatively. They only decide a specific dispute and responding to a specific legal case.
Sir, if there were a specific legal case addressing specifically the status of the field track in Smilno, would you accept that decision?
Of course, I could accept it to a specific case.
So now just follow up on one issue that you mentioned. You were explaining the potential for split ownership between the road, the body, the road as such, and the land on which the road is built. I would kindly ask you to review Exhibit R205, which is a judgment of the Regional Court in Košice in case number 6CO/188/2016, dated 31st of January 2017. So first of all, have you been able to review this decision earlier?
No.
Okay, so then I will just scale down on my questions, and I would kindly ask you to go to paragraph 43. So I represent to you the dispute was about the status of certain structure, whether it was a surface communication or not. And here we can read in 43, it has been proved beyond doubt by the evidence taken that no building permit has been issued for the communication in question, and that the communication is not included in the road's network. The Court of First Instance took for the basis also the decision of the Košice District State Office dated 14 August 1964, Article 77, by which the following structure was approved: Heat Plant Košice Mesto Facility 1. Within the said construction, the area of the facility was delimited by a zoning permit issued by Košice District State Office Construction Department dated 18 September 1963. The area of the construction as a whole was delimited that way, including land plots on which a civil engineering facility was subsequently established to connect between individual facilities. The documents filed by the plaintiff articles 142, 143 that are on the court file indicate how the communication in question looks like. It is clear from the layouts of the communication that it is demarcated the outer edges of ditches, gutters, embankments, and cuts of slopes, frame and cladding walls at the foot of retaining walls. It therefore does not meet the definition of a road body set out in the Road Act. In addition, it is not connected to the land plot by a subsoil that is usual for any structure of surface communication. It corresponds with the defendant's description of it, i.e. a concrete pavement layer with a thickness of approximately 20 centimeters. Therefore, it became fit for use as an access road to the plaintiff's plant, as well as to places of business and real property of further entities. And it continues in 44. According to the above, we can derive that from the legal perspective, the communication in question is not a surface communication that has an own legal regime. The appellate court is of the opinion that it is more appropriate to use term a civil engineering structure access road for that structure that does not have an own legal regime, but a legal regulation of the property land plot on which it is situated. Since the plaintiff is the owner of the land plot on which the civil engineering structure access road in question is located, which was not disputed in the proceedings, the plaintiff should be perceived as the owner of the civil engineering structure access road based on the land plot. So now I will ask, a few questions just on this. So, would you agree with me that what the court was resolving in this case was a communication which used to connect several facilities? Correct?
I disagree. Because this is reasoning of the judgment. And as far as I was able to see the judgment itself, the declaration, this was not the subject matter of the proceedings. But forgive me, this is the first time in my life I see this particular judgment. So I will likely be unable to respond to it in a relevant manner. However, if something is in the reasoning part of a judgment, there is no obstacle to res judicata. And if I only could have a glimpse at what was the subject matter in the declaration of the judgment, the question at hand, the fact in question was not this. I can only assume that in its justification, the court also spoken about this issue. But again, this was not binding because something binding is only the declaration of judgment and not its justification, which is binding. And if it were a part of the declaration of the judgment, it is not binding to any other legal matter or case, because the declaratory part of judgment, except for defined exceptions in procedure, is only binding inter partes. I'm not even sure who were the parties to this particular dispute educated by this court in this judgment, no matter who it was, but in its declaratory part, the judgment is only binding for those two parties to that proceedings. I have no idea again who it was. Truly, I don't know. So I would not dare say going to expert dispute with the court because the justification part is lengthy. And you understand that I would have to study it thoroughly in order to be able to relevantly answer these questions.
Sir, would you agree with me that we lawyers, when we want to see how courts interpret statutory and other legislative provisions, look precisely at the non-formally binding parts of court decisions to be able to see how courts interpret these provisions?
Yes, but most of all, we focus on the highest court authority's interpretation, which Košice Regional Court definitely is not.
And if there's no relevant interpretation by the highest authority, we may also look at the interpretations provided by the courts level, which are one level below. Can we not?
Yes, of course. Definitely, I agree. Especially when they convene, it is a part of the procedural tactics. So I fully agree, of course.
So I understand, sir, that your strong view on that it is your view that a field road is always a special purpose road, correct?
In principle, yes, if it meets the term particulars that we referred to earlier.
But by the particulars, do you mean the particulars set out in Article 1.3 of the Road Act?
I do not remember exactly those provisions of that article. I rather think it's about the executive decree to accompanying the Road Act, if I'm not mistaken.
So just to make it clear, and again, yes or no would be very helpful. So if we put back document, what was it, the law R175. Paragraph 1.3. So in your opinion, does a field road have to meet the definition set out in 1.3 in order to qualify as a special purpose road?
A brief answer, yes. One addition, the executive decree is called executive because it specifies in more detail these particulars. Meaning that in this case, lex specialis, the executive decree says verbis expressis about road tracks, sorry, field tracks, correction of interpreter, which meets certain points, which used to be a mine or a quarry. So I dare say that yes, it does meet the definition, answering your question. But my justification would go deeper, going into specifics stated by the executive decree.
Sir, is it your expert opinion that a definition in a decree can overrule or derogate from a definition in the law?
It is supposed to clarify definition. It is not overruling act, because act is a greater strength standard than decree, but it's supposed to in decree clarify terms promulgated in act, which in this case I think it has been done so.
But just to make the principle clear, if the law requires A, then that A must be met regardless of even an express provision in the decree that A does not apply.
It does apply in light of how it is clarified in executive decree. That is why it's called executive, that some things are being clarified by it. But I do agree with the fact that it should not go above or against the text of the act.
So that I don't have to wait for the lawyers to, in their pleadings, to interpret your answer for me, Professor, let me ask you a question directly. If a field road meets the criteria set out in Article 1.3 of the Road Act, Is it considered a purpose road? Yes,
Yes,
And then I will ask a follow-up question. If a field road does not meet the criteria set out in 1.3, is it considered?
it may still be considered a special purpose road because the executive decree establishes additional particulars when such road may be considered special purpose road.
Sir, that the decree cannot overrule a definition in the law, correct?
Yes, we did agree, of course. Everything I say is that decree is to provide more detail to act because it's an executive decree. So some terms we call vague in our logic are clarified further by the legislator through an executive decree, giving it more clear outline to what may and may not be considered field road. And if I may make an additional comment, I do not think that any field road in Slovakia would not meet the definition in the paragraph 3 of the Road Act, because no one has ever said what is considered a road body. All I say is that a regular commonplace knowledge of the issue means that any road, field road or forest road is comprised of a road body, but not such road body that there needs to be a same layer of tarmac as on first class road or motorway. To me, this is still a road body, even though it's a forest road, field road connecting point A with point B. I do not see a reason why it should not be a public special purpose communication.
So let me, you were referring to a decree, so let's have a look at the decree. The decree is document C 223. And here you were referring specifically to Article 22. So before we get there, I would just confirm for the record that this is a decree from 1984, which was issued at the time by the Federal Ministry of Transportation. And we can see in Article 22 that it says special purpose roads include in particular field and forest roads, access roads to plants, construction sites, quarries, mines, sand pits, and other objects, and roads in enclosed areas and sites. Can you see that, sir?
Yes,
Does that provision address the requirement for a road body?
I don't really know that. And in my view, no one at all knows this in Slovakia.
I apologize, it was an incorrect translation. So my question was, does this provision explains the statutory requirement that we see in Article 1.3 of the Road Act for every surface communication to have a road body?
I think I've already answered this question several times. I have no reason to change my opinion about this, but let me just point out, I'm no expert to neither transport law or road law, so I dare not say what is and what is not a road body.
I apologize if there were problems with interpretation. I will ask the question as simply as I can. does Article 22 of the decree address what road body is?
No, it does not. What is road body? But legally, by a demonstrative enumeration, it establishes what is considered special purpose road.
Okay, so is it your opinion that on the basis of this provision in the decree, a field road that does not have a road body is special purpose communication?
Yes, I do think so. And I also think that every field road does have a road body. Even though it's only a trodden dirt or driven whatever foundation there is, to the best I deem this a road body because it serves to travel from A to B.
So, sir, let's leave aside the factual question whether there is a road body or not. Just from a legal perspective, what you are telling this tribunal is that and we established that earlier, in Article 1.3 of the Road Act, every surface communication must have a road body, right?
I did not say, I would have to see it again, but yes, it is a part of the legal definition. But please, once again, it does not say what is road body.
You also agreed with me that special purpose roads are a subset of surface communications, correct?
Yes,
Therefore, if you look at the text of the law alone, special purpose roads being surface communications must have a road body, whatever that is.
yes,
So now would you agree with me that since this is a statutory requirement, this cannot be derogated from or overruled by Article 22 of the decree?
it's an incorrect question. I did say on multiple occasions that, of course, the act has a greater legal strength than the decree. Counsel in his question is ignoring the fact that decree clarifies a vague term which has been used in act. There's no clearer way I have to say this. I've been saying it for maybe 4 times now. The legislator here has clarified clearly a vague term in a manner that through a demonstrative enumeration have established that which is considered special purpose road, because the act you are referring to, Mr. Counsel, is not included, meaning that it is not a relationship of a hierarchy of regulations. It's a relation of executive decree to explaining a fairly vague definition of the act. And to my best opinion and conscience, I insist on this interpretation.
Professor, do you accept, and I think you do, but let's just clarify that the decree cannot contradict the act as a general proposition?
Of course, I do agree.
Are you aware, sir, of any other provision in the decree we have in front of us that would clarify the term road body?
No. But again, pointing out, I'm no expert to road law.
Okay, so I will now ask my last question on road law. And then it might be a good time to break. Actually, it's the last topic. We will see how many questions will be needed. I would kindly ask you to look at Article 2 of the Road Traffic Act, which is Exhibit R174. And we can read there that for the purposes of this act, road traffic shall mean the use of highways, roads, local communications, and special purpose communication, hereinafter referred to as road, by drivers of vehicles and pedestrians. Can you see that, sir?
Yes,
Agree with me that the term road is used to define 4 categories, namely highways, roads, local communications, and special purpose roads.
yes,
And this is actually the same 4 categories of surface communications that we know very well from Article 1, 2 of the Road Act, correct?
I suppose.
So now look at Article 21 of the Road Traffic Act. It states, when entering a road from a place off the road, from a field track, from a forest road, from a cycle path, from a residential area, or from a pedestrian zone, the driver shall be obliged to give way to a vehicle driving on the road. Can you see that, sir? No, sorry, I was just.
Prepačte, ja sa len pýtam, či si to vidíte.
Ja sa
Residential zone, give way, vehicle going. Yes, I can see this provision.
So I would draw your attention, sir, on the use of the term road at the beginning of the provision, and then the field track that we still have on the first line towards the middle. Can you see that?
Yes,
Would you agree, sir, that this provision distinguishes between road, as it is defined for the purposes of this act, and a field road?
yes. According to this provision, yes.
So would you agree with me that for the purposes of the provision, a road is something different than a field road?
Yes. However, the subject matter of this act is clearly defined differently than the subject matter of what we've discussed until now.
And therefore, would you agree with me that obviously for the purposes of this act, which is about road traffic, a field road is something different from a special purpose road, correct?
No, I cannot see it from this. It doesn't derive to me from this.
So if we go back to the definition that we saw in Article what was it? 2. In Article 2.1, we see that roads, for the purposes of this act, include highways, roads, local communications, and special purpose communication, right?
I do not have the Slovak text in front of me.
Ask that the Slovak tags be shown to the witness.
Please remind me quickly of the exhibit so I can pull it up on my own screen.
This is exhibit
174.
R174.
Thank you. Thank you, Madam.
Yes, so in Article 2.1, we can see a definition used for the purposes of this road. Sorry, of this act. And the term road means four things. It means highways, roads, local communications, and special purpose communications. Can you see that? So if we now go back to Article 21, we
Yes,
to change the screen in English, but we need to scroll down in the Slovak version. And now if I read it out loud by replacing the definition of road by its components, 21.1 would state when entering a highway, road, local communication, and special purpose communication from a place off the highway, road, local communication, and special purpose communication from a field track, etc. Do you follow me?
yes.
So this is why I put to you the proposition that for the purposes of Article 21, a special purpose road is something different than a field road, right?
Well, may I respond to this? Dear colleague, I come out of the criterion of a rational legislator. A legislator every time and under all circumstances call and make relationship between every provision they enact in order for the new provision to be fully compatible with the existing legal system. Now that's in theory, but in reality, not all provisions enacted are always coherent. And I think this is the very product of Slovak legislator not acting rationally. I don't want to speak on behalf of the legislator. This is not my place, neither the council nor me. But I do not think that the legislator wanted to achieve that what council is referring to. I do not think that the legislator has considered so clearly and on fine scales what you are referring to. But again, I am no legislator. I dare not respond on their behalf what they had in mind. But as a minimum, we have a conflict between two acts because definition used here is different one to the one used in the Road Act, if I'm not mistaken. So again, there is a discrepancy to which Madam President referred to earlier, and also during this hearing, we've pointed this out on multiple occasions. Yes, indeed, Slovak legal order briefly is not coherent, is not consistent. And that is why I would not make dramatic conclusions from this. Me personally, that the legislator wanted exactly to achieve excluding field road from special purpose roads, when in other piece of legislation they claim that yes, indeed, field road is special purpose road. I think this is an error on the side of the legislator and not their intention.
So, sir, you pointed out to an inconsistency, I believe, between Article 22 of the decree and these provisions of the Act on Road Traffic, correct?
Yes, but not only the decree, but also the Road Act.
Well, sir, the idea that every field road is a special purpose road is only stated in Article 2 of the decree, is it not?
Even I think not everyone is there as field road, but only the one meeting those term features.
No, so, sir, there may have been a misunderstanding. The only provision that you referred to as the provision stating that every field road is a special purpose road is Article 22 of the decree, right?
Yes, because there is no other legal statute addressing this issue in such detail.
And now hypothetically, if, and the decree is an act of the Ministry of Transportation, correct?
I think so.
The Road Act and the Road Act are both acts of the Parliament.
Certainly.
Now, hypothetically, imagine the Parliament makes a terrible mistake and they enact a conflicting provision to a decree because they are completely incompetent. As a matter of law, what will prevail? The completely incompetent provision adopted by the Parliament or the very rational provision in the decree?
I can imagine quite clearly such situation. And it has happened on multiple occasions, in fact. And based on the doctrine of sovereignty of the legislator results that no matter how incompetent, it will prevail any lower statute.
Thank you. This may be a good moment to break, Madam President.
Good. Do you have an idea how much time you need?
I have covered 70% of my outline.
Good. Fine, and we'll have a 15-minute break now. Professor Stavcek, I would like to ask you not to communicate with anyone about the facts of the case or your testimony during the break. And we'll see you again in 15 minutes. Thank you.
I look forward to it. Thank you.
So, Professor Stavcek, you're ready to continue?
Yes.
And Mr. Spector is too. Good, please go on.
Thank you, Madam President. Professor Ściełczak, we will now switch topics and discuss the preliminary injunction against AOG, which was issued by the district court in Bardejov upon the request of Mrs. Varianova. Is it still your opinion, sir, that the district court in Bardejov did not have jurisdiction to issue the injunction?
Definitely, yes.
Now, assuming, just for the purposes of my question, assuming that the field road in Smilno was not a public special purpose road, would the district court have jurisdiction to issue the injunction?
Yes.
Let's have a look at the claim which Mrs. Varianova filed. It is document MS5. And it would be helpful to have the Slovak original of the document to, perfect, yeah. So the Slovak version of this document is actually longer. We only have a partial translation into English. I would just ask you to confirm, sir, have you seen the full Slovak version of the request?
I cannot confirm that because I think I have the motion and the action was not given to me to my disposal.
So just to confirm, the Council for Discovery only showed you the motion for interim injunction, but did not show you the action that the motion.
No, I was based on court decisions only.
Okay, so you did not even see the request for interim injunction, did you?
If I'm not mistaken, it has been a few months to years, so the answer is no.
Okay, I will just then go through that very quickly. Let's first look at the action. This document MS5 we have in front of us. But you are aware, sir, that the action was for declaration of nullity of an agreement that AOG entered into with one of the many co-owners of the field track. And Mrs. Varyanova was seeking declaration of nullity of that agreement due to violation of her rights of first refusal. Apologies, there was very incorrect Slovak translation. The right of first refusal was translated literally. So maybe if I say right, preemptive right.
Yes, I'm aware of these factual circumstances.
And the request for interim injunction, which is actually part of that action, states that as follows from the enclosed letter of Juris Doctor Robert Slamka, the first defendant, after the registration of its ownership right in the land register, requests the conduct from the plaintiff that would, according to his arguments, respect his co-ownership in the land, in the lot of land of the e-register number 2721/780 in the cadastral territory Smilno, registered in the ownership certificate number 1367. Despite the fact that, as is clear from the motion to commence the proceedings, the first defendant has a 1/700 share in the relevant common property, his supposed right to use the property according to his ideas, he not only claims with the attached letter, but repeatedly uses self-help and without anything authorizing him to do so, removes from the relevant property the motor vehicle that the plaintiff has on rent. Despite the fact that the plaintiff has repeatedly turned to the police in this regard without immediate intervention by the court, she cannot prevent the first defendant, either alone or through third parties, from repeatedly physically manipulating the motor vehicle that the plaintiff has on rent, and for the condition of which the plaintiff is responsible. In case of repeated removal of the said motor vehicle, there is also a risk of its damage. The plaintiff has the consent of several co-owners with her procedure in using the relevant lot of land. So this is the factual description provided by Mrs. Varyanova in support of her request for interim injunction, correct?
I expect so.
Would you agree with me, sir, that the way the problem is described here, it is a dispute between co-owners regarding use of a land plot that they co-own?
Yes.
So one co-owner wants to have a car parked there, and the other co-owner does not want that car to be there, correct?
Definitely not. This is not how it's been formulated. The action and on merits is about relative invalidity of a legal act. That's okay. It's been a dispute between co-owners, and a motion to grant interim injunction at that time aims, I don't remember exactly, here it is, I do not see the very request for relief. I cannot see the request for relief in that motion. Can I perhaps see that?
In the interest of time, we will come to the request for relief. What I am asking you to confirm is that the way Mrs. Marianova describes the problem here, the problem for which she seeks the interim injunction, is a dispute between two co-owners regarding whether one of the co-owners' car can be parked on the land plot or not.
He's already said yes, I believe.
I disagree. I don't agree. This is not how it has been formulated. It was about a motion, action to declare relative invalidity of a legal act.
Sorry,
А з тим
sir, please.
поставити висвя hetzelfde.
And related or not related with that is the issue of an interim injunction, but not on the merits. Madam Marianova had requested invalidity of a legal act.
Sir, there may be translation issues.
May
for
I,
which-
may I ask one quick question, please? And I don't mean to interrupt, but so as to correct my apparent misunderstanding. Perhaps I'm the only one in the room who misunderstood. Do you agree, Professor, or excuse me, no, that's not for me to ask you that. Do you consider, Professor, that the way the problem is described here, it is a dispute between co-owners regarding the use of a land plot that they co-own?
Do you think described wherein?
Excuse me, is that a question to me? In the request for interim injunction, is the dispute as described in that request a dispute between co-owners regarding the use of a land plot that they co-own?
If it's formulated like this, then yes.
Back to you, Mr. Pekash.
Thank you. Thank you. The beginning of the description starts with reference to an enclosed letter of Juris Dr. Robert Slamka, the first defendant, Now, I represent to you that the document that we will now show you on the screen is this letter. So this letter is Exhibit R36, tab 8. So what we can see here is the letter sent by Mr. Robert Slamka to Mrs. Mariana Varianova on 30 December 2015, correct?
Yes.
And what we can see in bold is that it states call for the removal of the barrier to entry to the plot on EKN maps. Plot number 2721/780 arable land with an area of 11,660 meters squared, registered on the ownership certificate number 1367 for the cadastral area Smilno, municipality Smilno, district Bardeo. Can you see that, sir?
Yes.
So, then we have the text of the letter. In the first paragraph, Mr. Slamka explains that he's been duly empowered to represent the company Alpine Oil and Gas, correct?
I've not seen the power of attorney, but I have no reason to doubt this.
And then he presents the call requesting Mrs. Varianova that within 3 days of the receipt of this request, Mrs. Varianova is requested to remove the motor vehicle of white color as seen in the attached photo, which is allegedly leased. By you personally, as through this unlawful act, you are hindering the co-owner, the company AOG with its address represented and so on, in the entrance and transit passing through the plot of land 2721/780 arable land with an area of 11,660 meters squared, registered on the ownership certificate 1367 and so on. Can you see that, sir?
Yes.
Would you agree with me that the way Dr. Slamka puts the issue is, again, a dispute between co-owners?
Yes.
So, sir, do you agree with me that civil courts have jurisdiction to issue interim injunctions in disputes between co-owners that regulate relationship between co-owners?
Of course. Definitely yes.
And as we know, on the basis of its request, the other evidence attached to it, and this letter, Mrs. Varianova obtained the issuance of a preliminary injunction. Correct?
Yes, she achieved it.
And the injunction became applicable immediately upon delivery to AOG, correct?
Yes,
AOG had the right to file an appeal against the injunction, correct?
yes,
The appeal, however, did not state the applicability of the injunction, correct?
I don't know if it's spoke about the enforceability.
No, apologies, there was an incorrect translation into Slovak. I will say that again. The appeal, however, did not stay the applicability of the injunction, correct?
I understand the question correctly. The appeal has no suspensive force on the enforceability of such injunction. So yes,
Would Mrs. Varyanova have been liable for damages caused by the injunction if the injunction had been quashed on appeal? Yeah,
I don't understand the question.
I'm not surprised you don't understand the question. Would Mrs. Varyanova have been liable for damages caused by the injunction if the injunction had been quashed on appeal? No.
If you now are referring to the diction of the section 77/3 of the former Civil Code of Procedure, that stipulates such responsibility for damages of the preliminary injunction applicant.
So would it be fair to say that under that provision, there is a certain balance? On the one hand, a preliminary injunction is always issued just on the basis of a request of the applicant without giving the other party an opportunity to say anything about it in the first instance proceeding. But on the other hand, the other party may file an appeal. And if the appeal is successful, then the applicant is liable for any damage caused by the application of the interim injunction that it.
No?
Yes, I agree. It would be responsible.
And isn't it true that the same rule applies if the applicant loses the main claim on the merits?
Well, Civil Code of Procedure has not been enforced for the past 8 years nearly, but I think back then that's the way it worked.
So in our case, Mrs. Varyanova would have been liable not only if the interim injunction had been quashed by the appellate court, but also if she had lost the main claim regarding validity or invalidity of the agreement between AOG and Mr. Tomacek.
Yes, in general, one can say it this way.
So let's look now at the appeal which was filed by AOG, and this is document LF17. Sir, did you review this document when you were preparing your expert reports or in preparation for this cross-examination?
No, I only based my preparation on court decisions.
So you would not know, therefore, sir, whether AOG argued in the appeal whether they had the right of general use of the field track under the Road Act, would you?
I cannot tell this from this appeal, but from other documents, it resulted that this is not what they were referring to.
So from these other documents, do you know whether AOG stated in the appeal that the land plot on which Mrs. Varyanova was parking her car was a public special purpose road?
As far as I can remember correctly, it was more or less undisputable that they did not refer to this, but this has been the procedural tactics of the council, Dr. Slamka. So I would not like to comment on that.
Okay. So, Professor, let's look now at paragraphs 22 to 24 of your first expert report, where you discuss the conditions for granting an interim injunction. So, would you agree with me, Professor, and I'm speaking obviously with respect to the then applicable legal regulations, so I'm speaking of the what we call the Code of Civil Procedure, that in terms of the then applicable legislation, one of the conditions for granting an interim injunction was a threat of imminent harm, correct?
Oh, no.
Yes.
And now if we refer to Article 75(2) of the Code of Civil Procedure, which is LF4,
Which of course the witness knows by heart from back to front, right?
so this is Article 75(2),
Right.
please. Okay, so we are there. 75(2) states, apart from the terms of the petition under section 79 subsection 1, the petition shall include a description of the decisive facts justifying the order of the interim measure, the statement of conditions of eligibility of the claim to which the interim protection is to be provided, and the reasoning of the risk of imminent harm or the need for a temporary arrangement of minor childs and so on. So you can see here that what the text of the law requires is the risk of imminent harm, correct?
Yes.
So now in paragraph 16 of your expert report, you argue that this actually is a high threshold. And in fact, the harm must be significant, serious, and even irreparable. Can you see that?
Ano.
Yes.
So we will return to the legal standard later on. Now I would just like to follow your reasoning and turn your attention to paragraph 22 of your first expert report, where you state broadly that the threat of harm can only be derived from Mrs. Varyanova's description in the application, and hence the imminent harm arises from the risk of damage to the motor vehicle which the defendant allegedly disposed of physically, moving the vehicle from the place where the applicant had put it. Can you see that, sir?
Ano.
Yes.
And then in paragraph 23 of your first expert report, you state that that argument would succeed if the applicant herself did not violate the law, if she had parked the car in an ordinary parking space and someone would be trying to move her car. Can you see that, sir?
Yes.
So when I am to apply your standard of harm that needs to be certified in accordance to what you say in paragraph 16, the removal of a car from a parking lot would meet that standard, correct?
I don't know. I have not considered this. I have been considering specific merits of the situation, responding to specific questions put to me.
But sir, if I read the first sentence of what you have in 23, you say that argument would succeed if the applicant herself did not violate the law, if she had parked the car in an ordinary parking space and someone would be trying to move her car, right? Can you see that sentence?
Ano.
Yes.
So to me, that sentence is very clear. If I park my car in a parking space, someone removes that, I may go and obtain an interim injunction against the person doing so, right?
Yes. As long as the vehicle was placed on a road. So the councillor himself just admitted that this is a special purpose road because that's where the car was clearly parked. A car may park outside of roads. So thank you.
There may have been
No,
some
I don't,
translation issues.
there may have been some communication issues. I don't think there was any admission.
So now, what if I am the co-owner of a field and I park my car on that field and someone removes my car from the field? Would that satisfy the threshold of imminent harm required for the issuance of an interim injunction?
Nie,
No. I would have to specify in what manner such harm were to occur, because only by towing a car away to get from A to B, that on its own does not mean that there is an imminent harm threatening to my property or otherwise.
So you are telling me that if I park my car on my land and then someone comes in every day and tows it away from my land, there's no harm to my property?
Not necessarily there has to be damage to your property, because by towing a car, within the meaning a towing service, towing away a car, but only maybe moving it a little bit, does not necessarily have to result in damage to the car itself. But we keep forgetting one fact, and that is, I clearly state that the prejudicial issue here is that this was not the land on which the co-owners wanted to grow corn, but they were intending to use this land for transit from A to B. So if I place my car on a special purpose road, serving for transport from A to B, clearly by that I am preventing others, even other co-owners, in proper use of that land. And I claim that not only to the co-owners, but since I am fully convinced this was special purpose road, not only to the co-owners, but also to the broader public, I'm preventing them to adequately use such road.
Well, there are several components I would like to address. So, so the first component is that you assuming it was a PSPR. Okay, apologies. That's a public special purpose road. Okay, so assuming it is a public special purpose road. So if I see, for example, when leaving this building, I go on back to my hotel and I see that there is a car in the road, do I have the right to tow that car or have it towed somewhere else? I was assuming.
Tak to podle mě povedať nedá.
I don't think one can put it this way, because also in the civil code in Slovakia, you have Article 6, which says about self-assistance, meaning that if you meet the conditions of defensive self-assistance, in that case, I think, yes, but this would depend on the circumstances of the case at hand.
Okay, and it would be for a court to assess whether the conditions for self-help were met or not, correct?
Kde nie je
Well, there is no accuser, there is no judge, so it's not up to the court ex ofo to examine such actions. In a vast majority of cases, these things never get to the court because it's usually resolved right on the spot, according to Article 5 of the Civil Code, and the municipality has authority to intervene. So answering a question, yes, if it ever got to the court, that is that body which in this case is capable of and empowered to judge whether or not this has been legislative done within the legislative framework of self-assistance.
Okay, so we will turn to that later. Now I am interested in the legal standard of the harm that is required. So first of all, there doesn't need to be actual harm. It is sufficient for a threat or risk of harm to be there, correct?
Sorry, can I just cut in here? I mean, this is all obviously for you to decide how to proceed, but I could just ask the witness, the bottom line is it not your view, your opinion, that the first instance court got it wrong and it should not have given an injunction? Is that your view?
Exactly, yes.
The case then went on appeal. The injunction was upheld. And your opinion is the appeal court got it wrong. Is that correct?
Yes, I claim it also in my report that the also regional court in Prešov was wrongful due to the reason that ex officio they were supposed to examine their power, their jurisdiction. In fact, not only on merits, there was existing jurisdiction on merits, but the jurisdiction on granting interim injunction, and that is where I claim, as resulting from all the facts of the circumstance, it is clear that everyone was only interested in transit over that road. Madam Marianova and everybody else, beyond any reasonable doubt, were only interested in transporting mechanisms, vehicles, if I put it that way, over that road. So in this case, I think that as particulars were met of public special purpose road, the court was supposed to have judged that there was no jurisdiction for the court to grant such interim injunction. I'm hearing myself, forgive me, because I have an echo in my headset.
Could you help us, poor arbitrators sitting in London who have no background in Slovak law, know nothing about the status of Slovak courts? Could you tell us something about the status of this appeals court in the Slovakian court system? How significant a court is it?
Every court is ipso facto an important body of protection of law. If you're asking about the structure and hierarchy of the Slovak judicial system, regional court is a typical appellate court, meaning that it is to serve to remedy any wrongdoings of those district courts, or now even municipal courts we have, placed within their jurisdiction territory. Regional court has no jurisdiction to adjudicate general conclusions. And its precedence effect of its judgments only relates to specific matter or case within the instance process. Above the regional court, there is another court called the Supreme Court of the Slovak Republic, even Constitutional Court, which both have the authority to correct their decisions, judgment, but only based on initiative. It's a remedy, either called extraordinary appeal in civil proceedings or constitutional complaint in constitutional law concept. So that means regional court is a middle level of the judicial system, under which there are district courts, above which there is Supreme Court of the Slovak Republic and Constitutional Court of the Slovak Republic, which also has the authority to overrule decisions of regional courts. Hopefully this has been a sufficient explanation. Please ask for more to elaborate.
Are the judges on the appeals court independent?
Of course.
Do you have any evidence that the judges on the appeals court decided as they did on the basis of any pressure brought upon them by the state?
Definitely, I've never in my life have heard anything like that, so no.
So although your opinion would be, although the court got it wrong, the appeals court got it wrong, it exercised independent and impartial judgment.
No doubt, yes.
Thank you very much.
Thank you. I'll go back to my now significantly reduced line of questioning. Please, let's assume that the land plot on which Mrs. Varyanova was parking her car was not a PSPR. We already established that in that case, the courts would have jurisdiction. But now my question is, was the granting of an interim injunction justified in that case on the facts certified by Mrs. Varyanova in her request for interim injunction?
If on that land there was no PSPR, Madam Varyanova was not supposed to be placing her vehicle there whatsoever, because she would have violated the law. Because motor vehicles may only communicate over surface roads if Madam Varyanova drove on field road or forest road or not. I take it back. Only driving on her own land, which would be a forest or arable land, she would then, I think, violate, it would be a misdemeanor. I don't know if that at that time, back then, this was legislated. I really don't remember. But from a certain point on, it is even a misdemeanor, driving off cleared roads. So from this point of view, I'll deem that equally the principle would apply. Nemo tulpicinem allegare potest. So if I myself violate law, I may not expect anyone else to be provided to me relevant protection. So if Madam Varyanova parked on a public special purpose road or parked on her land, however, which would be both either forest land or field land, in both cases, she would be violating the law. So in this way, I deem that in neither one of the modalities, an interim injunction should not have been granted.
So when people in Slovakia park their cars in their gardens, which are registered as gardens, all of them violate the law. Is that your testimony, sir?
Yes, yes.
Okay, so now let's look at the decision. All right. Of the district court in Bardeo, which granted the injunction. So this is document C-125. And I'll draw your attention to what is on this page 7 of the English translation. So in the middle of it, now that would be like the 10th line. 1, 2, 3, 12 on line 12. It states all the more that it is inadmissible for one of the co-owners to interfere with the rights of other co-owners, or to damage the rights or things belonging to the other co-owners without a legal reason, and to use the cell Help Institute in such a way. Please see the wording of Article 6 of the Civil Code. The question, what was the immediate threat of unlawful infringement of a right of the first defendant to avert the interference himself in an appropriate way? Or if there was an interference with his co-ownership rights, why did he not demand a protection from the relevant authority, e.g. before the court, etc.? If there is any disagreement between the co-owners regarding the management of the joint property, it is necessary to submit a proposal according to Article 139, paragraph 2 of the Civil Code, and not to threaten the exercise of the rights of other co-owners in this way, in this case of the applicant. So would you agree with me, sir, that what the court expresses here is the court's opinion that the resort to self-help by AOG, by towing away Mrs. Varyanova's car, was inappropriate?
I would not agree, because the court, in its resolution on granting preliminary injunction, did not conduct any evidence. Meaning that this claim is based on, likely, I can only assume, from the claims of the claimant. But this is not what the court states, and I'd like to remind you on the fact on decision justification and the reasoning, because only the judgment part of a decision is applicable when there has been no evidencing. Court then did not have established facts whether self-help or not has been eligible.
Okay, so I appreciate you state this is what the court said on the basis of the description provided of Mrs. Varyanova only, right?
Nepovedal som, že výlučne a
I did not say exclusively, I said likely.
Okay, but so you take issue with what the court says because you say facts were only certified instead of proven, right?
áno, určite.
Yes, definitely, they were not proven.
But would you agree with me that if it were actually, factually correct, that AOG had towed Mrs. Varyanova's car away several times, exactly as Mrs. Varyanova described it in her request for interim injunction, then the court's disapproval of such actions by AOG would be perfectly valid, right?
Yes,
I'm a little lost in your question, I have to admit, but if I may respond before you clarify, I would definitely, in this case, not use self-help as a private legal institute, because I claim that this is the public law regulative, since this was a case of public special purpose road. And in this case, I would refer, I myself back then, if I had been involved, I would refer to the municipality as the body which with jurisdiction to issue even sanctions for blocking public special purpose road. I am not certain or sure why AOG back then has reverted to self-help. In any event, I think it would be more correct to refer to the municipality whose power it is to administer public special purpose roads.
Sir, would you agree with me that precisely because self-help is an institute of private law, it is not acceptable for anyone to use self-help to enforce his or her putative public law rights?
I guess this is for a full expert book. But in principle, if we base this on the thesis of relative independence of, in the continental legal system, independence of private and public law. So the overlaps of one into the other should be quite rare, relatively. However, at this moment, I would have to think deeper about the question whether I may, as a self-help, defend public subjective law. I would lean towards saying yes. But again, I repeat, this would require much deeper pondering other than responding like this ex abrupto.
Okay, so we may look at what the appellate court had to say about the conduct of AOG. We have it in document R063. And if we look at what is the third paragraph in the English version on page 6, so it also happens to be the third paragraph in the Slovak original. So we can just see there that the regional court says the defendant one must have expected from the very beginning that a legal construct allowing it to carry out geological exploration on a third-party land through an already invalid purchase of a tiny co-ownership interest may fail. As to whether defendant one acted in good faith, it can be reliably stated that the conduct of defendatory caution. Defendant one could have been well aware that purchase of a minuscule co-ownership interest without respecting the preemption right is very close to violation of ownership rights. It is evident that business activities of defendant one were based from the very beginning on mala fide manner of communication with owners of the affected land. From such a point of view, the conduct of defendant one lacks any bona fide trait. Can you see that, sir?
Yes, I can see it, but I don't agree with it.
But I think we have established here that the court disagreed with the acts of AOG, correct?
Is this a resolution on the interim injunction?
Yes.
Nie je to rozsudok vo veci samej, čo teraz pýtame.
This is not a judgment on the merits.
Well, this is the decision of the appellate court, the regional court in Prešov, on the request for interim injunction.
Tak. V tom prípade
In that case, it applies what I've said before. That definitely the merits have not been established, quite definitely. But I dare to say here that the original court made a gross violation, even legally. If I may spend a minute to explain why, I'd like to do so. The concept of apologies to interpreters, concept of relative invalidity of a legal act does not mean at all something which is not acting on good faith. That's a gross misunderstanding of the principles Slovak private law is based upon. Because relatively invalid legal act is considered valid until someone will doubt it. So at that time, it has been a normal valid act. Even at the time of granting interim injunction, this has been a normal valid legal act. When this judgment was made by court on the merits, one could say this has been invalid. Until then, it's considered valid. And unfortunately, or maybe fortunately, in the Slovak jurisprudence, there are maybe hundreds of cases when a relatively invalid legal act is not disputed by anyone. So then it becomes a normal, relevant legal act, meaning that the court here assumes the right to decide how at the time X to consider, I don't know how many hundred co-owners. I think simply with even with the most benevolent interpretation of statutes cannot hold. No thesis of lack of acting in good interest or on good faith couldn't exist, because at that time the legal act has been a normal, valid legal act, and that is the substance of the concept of relative invalidity of legal act. It is not unlawful ex lege or absolutely. It only becomes invalid based on court's judgment when someone, understand different co-owner, would ask for such invalidity to be judged. But when the preliminary injunction motion was filed, court was not aware of that. So that is why I disagree.
Well, sir, I believe this regional court decides on the basis of the procedure that had been conducted both before the court of first instance and then the regional court, right? So we are not at the moment when the request for preliminary injunction was filed, right?
Well, I'm not certain I understand, but granting interim injunction is one thing, but deciding by court on merits is different matter altogether. I apologize if I'm wrong, but if I remember correctly, at the time of Prešov regional court making decision on appeal against the injunction, no merits have been decided yet whether the legal action is invalid or not. This is what I'm talking about.
Okay. Now, if you look at the last two lines, actually, what the court says was mala fide is the manner of communication with owners of the affected land, right? The court here does not refer to the conclusion of the agreement with Mr. Tomacek, but to something different, broader, to the communication with the co-owners. Can you see that, sir?
If you mean the second last sentence, it is evident that from the start of the business activities of the other mala fide manner communication with owners, affected land. I can see that, and I've already responded to that in my previous remarks.
Well, sir, I apologize, but you have not, because in your previous remark, you were commenting on the conclusion of the agreement in violation of preemptive rights, and you were stating that that agreement had to be seen as valid until it was declared invalid by the court as a part of Mrs. Varianova's claim on the merits. But what I am telling you here is that the court refers to the communication of AOG with the owners in plural of the land plot. So the court here does not comment on the conclusion of the agreement, but on a much broader issue of AOG's communication. Isn't that right?
Yes, I understand now what you are asking about. I don't remember exactly how many co-owners there were, but I suppose from my own professional background that in many cases, it is basically unthinkable to communicate with all co-owners, because very often it happens that several co-owners cannot be found. They are instead represented by the Slovak land fund, or they could be forest owners, co-owners. I'm not specifically familiar with the specifics of this particular case, but to blame someone with lack of bona fide that they did not communicate with all owners is not, or doesn't always have to be valid as this claim. Once again, I do not remember the number of the co-owners, but if I remember correctly, there were on the order of dozens of co-owners, and it's going to be quite difficult for anyone to communicate with all at once. As it seems to me, it is stated here by the regional court in this document, because as you put it rightly, they use plural, so to communicate with all co-owners with the best of intentions, I cannot imagine realistically to be done.
Well, sir, I just one very last question. Do you agree with me that the extracts from the land registry in Slovakia, which show the title deed for any plot of land, also show the registered address of each of the owners?
Áno, mohli by obsahovať prvá.
Yes, they should include the address of residence of each co-owner.
Therefore, if I want to give the people a fair opportunity to exercise their preemption right as I'm required under the law, I just send them a letter to the address which is stated in this publicly available register, don't I?
Doesn't always necessarily have to be that way. I apologize, but even I don't live on my permanent residence address. I am perhaps violating some small misdemeanor towards my municipality, but not really because I've registered for temporary residence, but the regular, it happens quite commonplace, but people do not live at their permanent residence address. Secondly, I once again like to dispute the thesis that I'm acting against the law in violation of with law. I do act in accordance with the law until otherwise is proven to me. I'd like to emphasize that. Once again, statute does not give me the obligation to approach every one co-owner. The civil code, I mean, only establishes the right of the co-owners to dispute transfer by motion on deciding on a relative nullity of such act. So it's not me having the initiative that one purchasing the share of land, but it should be other co-owners having the initiative. And also, this is only an inductive argument and not deductively valid argument. From all the co-owners, only one disputed such legal act. So all the others are satisfied with the act. I cast no doubt on the fact that even one such co-owner has such right. But I'm disputing the thesis that I was supposed to approach everyone because they all were interested on obtaining that one small share of the land. I'm quite certain this cannot be claimed.
Okay, so sir, under your interpretation, the preemptive right under Slovak law is a catch me if you can type of provision.
I don't consider this worth commenting.
Well, then I don't consider it worth asking you further questions.
Ďakujem.
Thank you.
Any questions in redirect?
A couple, they will be very short, I promise you, Madam President. Professor Stevchek, this is for the reference in the transcript at 11:47. Do you recall being asked whether you saw a copy of the request for an interim injunction that had been filed by Ms. Mariana Varianova before you signed your expert reports? Do you recall that?
That what occurred today, you mean?
Yeah, perhaps I can do this in this way instead. If you could please be shown exhibit MS5. And if you could, yes, exactly. And in the Slovak, if you could move forward, please. I think it's to page, if we go forward a couple of pages. And again, yes, there. So Professor Stevček, you were asked whether you saw a copy of this document before you finalized your expert opinions. And your answer in the transcript was, if I'm not mistaken, this has been a few months to years. So the answer is no. Can you confirm whether you saw a copy of this document before?
Ano, to sedí.
Yes, that is correct. But truly, I don't remember having seen a copy of this document, but I have seen all relevant matters of facts compiled in court decisions. I can certainly confirm that. I do not remember this specifically having seen this particular document. As you know well, the documents were being provided in tranches over time. I did not have them all available. There were multiple versions of my report. So to my best of conscience and knowledge, I do not remember ever having seen this particular document on display.
Could I refresh your memory, please, by reference to another paragraph in your witness statement, in your expert report? Could you be shown your second expert report, please, at paragraph 25? It should be page 9 of the English. I'm not sure which page in the Slovak it is.
This is the wrong expert report we have on the screen.
That's Professor Fogash. So Professor Stevček's, please. Thank you. And page 9 of the English, please, and then the equivalent. And then over one
Further
page
down.
in the Stevček, in the Slovak. Yes. And Professor Stevček, do you see in footnote number 6 a document MS5? And it's referred to in the paragraph as the request for granting an interim injunction. Does that refresh your memory about whether you saw this document before you signed your second expert report?
MS5.
MS5. Oh, MS5 is the document you shown earlier. Of course, no doubt about it. Please do consider that it has been at least a year and a half since I have seen it. So please, this is what you should attribute it to.
In that rule.
No, I think I understand the answer that you had seen the request.
Yes, no doubt. From this evidence, it becomes clear.
You even refer to it in paragraph 25 and the 9th line from the bottom. So
I don't have.
Môže byť, prosím, naozaj tých
It could be, please. There were extreme number of documents and not everyone I remember exactly.
Of course. My second question, re-examination, and this is transcript at 10:48. You were asked if there were a specific legal case addressing specifically the status of the field track in Smilno, would you accept that decision? Do you recall that question?
Yes, I remember. It was about the Košice Municipal Court.
Yes. Could you, are you referring to the decision of the Košice Municipal Court there? Is that what you're referring to?
Not sure we're speaking about the same thing. Mr. Counsel, this morning shown me some judgment, and I remember that being Košice Municipal Court judgment. But this was a original court, Košice, but I'm not sure the question.
Perhaps I could do it this way then. Could you be shown exhibit R059, please? Professor Stevček, have you seen a copy of this decision before?
Samozřejmě, to je usnesení.
Of course, this is a Russia Original Court resolution on appeal against, if I'm not mistaken, the interim injunction motion. Yes, of course, I have worked with this particular document.
This document is different from the resolution of the regional court in the proceedings that were originally brought by Ms. Mariana Varianova. This, I will represent to you, is a decision in connection with an application for an interim injunction that was brought by AOG against Ms. Mariana Varianova in late 2016. And my question is, have you seen a copy of this decision before?
Once again, if we are speaking about the Russia Original Court resolution by which it dealt with appeal against decision of the Bardeo District Court, and if I remember correctly, on granting interim injunction, then yes, I have been working with this particular resolution.
Stevček, this is a different application for a different injunction. And this application is brought by AOG, not against AOG, and this is the appellate decision on their application.
That is in the vice versa. So AOG was the applicant and Madam Varianova was the defendant in this case. This is what this will be discussing, yes?
The others, yes. Now, I don't know what the question is.
The question was because Professor Stevček said if there were a specific legal case addressing specifically the status of the field track in Smilno, would you accept that decision? And the professor was not taking to this particular decision. So I was just going to ask him a few short questions about it with leave of the tribunal.
That's fine, yes.
Professor Stevček, just take a moment, if you could, to familiarize yourself with this decision. And I will ask you whether you agree with the court's analysis in this decision.
Si ho teraz prečítať?
You want me to read it now?
Well, perhaps we can do it by coming to paragraph 11 and onwards. So on page 4 of the English. So if you could read paragraphs 11 through to 15, please.
Áno?
Yes. Court only quotes applicable legislation. One may not either agree or disagree with it. One may only acknowledge it.
Well, let's look at paragraph 15. In paragraph 15 of the judgment, the court says, if the claimant claims that the access field road is a public special road, it is necessary to point out that the Road Act, Communications Act, put certain restrictions on the road use. When using a road, users must adjust themselves to the construction technical condition of the road, which the appellate court does not perceive as fulfilled in this case with regard to the field road condition. And my question to you is whether you agree with the court's analysis there or not.
But do we agree that the analysis is hypothetical? It adopts the standpoint of the claimant.
Exactly,
yes.
yes.
Oh, Madam President, I'm sorry to interrupt.
Pani predsednička, prepačte, že vám do toho vstupujem.
Actually is a misrepresentation because it's not the analysis of the court. It's just a recital of what is stated probably in the request. No, it's not clear to me whether 12, 13, and 14 refer to what the court says, or if it just follows from 11 and repeats what the applicant had said.
That, yes, we'll have to read this carefully, but that seems to be the case at first sight, at least, yeah.
Could we move on possibly then, just one further paragraph in the judgment? This is paragraph 24. And my question is whether you agree with the court's analysis in this paragraph.
I disagree. I think I've quite broadly tried to explain it over the past hours. So once again, I cannot agree with this because the court claims that the land and any other road on it is a single unit, with which I disagree. These are two legal entities, excuse me, which could have and do have different legal mode. In other words, if I may add, read the first sentence saying the owners of the land are also owners of the field road located on the land. Forgive me, but this is a gross disrespect to Slovak legal system. There is no such superficial principle enacted, meaning that in Slovakia is a very commonplace that landowner entity A and any entity owner such as shrubs, structure could be entity B on the same land. So I cannot, as a civil law professor, subscribe to this particular claim here.
And what about paragraph 26? Do you agree with that court's reasoning here?
Oh, definitely not. I don't want to offend anyone apart from that, but the sentence saying that even single co-owner would express their dissent simply is not in line with the current legal system of Slovakia. That's all I can say to that. I'm sorry about that, but under no circumstances can agree with this. Well, just to understand me, please. Co-owners in the mode of co-ownership in the Slovak civil law, there's a majorization principle applicable. So the size of the share is important. So it's not thinkable, forgive me, for anyone to claim that even a single shareholder of or co-owner of such share of land would have legal consequences. It would apply if a single co-owner would have a majority share compared to all the rest of the co-owners, which in this case was not the case. So the sentence logically cannot be true.
Can I ask you one final question about this decision? Could you move forward to paragraph 29, please? Could you just read that paragraph to yourself?
Yes, I'm trying. I cannot agree with that. Then again, this ignores applicable legislation. The last sentence, regardless of whether this is or not public road, because non-public special purpose roads are only within a single enclosed area. Everything else are by default public special purpose roads. So the last sentence is completely ignoring the applicable legislation. In the first sentence, if I may, that the on the access field to Smildo has no, where's the legal certainty in Slovakia? Who else would have the power to decide whether or not this is a public special purpose road, if not the either Ministry of Transport, which based on the Competence Act is authorized to interpret this. Well, this is a non-binding interpretation, mind you, and the municipality of Smilno, who equally empowered the municipality by applicable legislation. Now, what is binding legal act? Then I think we resign completely on the fact that the public administration and self-administration bodies to people, but to entities, they are supposed to help them. So based on this interpretation, it would mean that the public power bodies must do all they can for people to be confused about this. That entity who is supposed to tell them how it is would not. And how can one then live in such country when someone else, it is not my jurisdiction, I take my hands off of this? Well, then the rule of law would have to cease exist in Slovakia. I'm sorry, I apologize. I'm kind of disagreeing with this. Public power bodies are here to make easier the lives in complex legal relationships to people and other entities. If we were to adopt this thesis, we would then resign to such system. That is why, forgive me, I must not agree with this.
And my final question is, my understanding is that this decision was issued in connection with an application for an interim injunction. Does any part of the decision establish a binding legal precedent under Slovak law?
Now, the term of precedent, I know we are formerly in the British soil, but the precedence in continental law is a very doubtful. We do have in the Slovak legal system precedential binding, but within the instance procedure on a specific case without general binding effect. So neither Prešov Regional Court or Bardejov District Court do not have the power, authority to formulate legal precedents. Even the Slovak Supreme Court or Constitutional Court, it's in their case, it would be theoretically very doubtful whether they can formulate a precedent. So definitely not a precedent, but with the highest court authorities, their judgments have a very powerful interpretative effect. But once again, these are not binding precedent. So no Prešov Regional Court or Bardejov District Court are capable of formulating such precedents.
I have no further questions. Thank you, Professor.
Thank you. Do my colleagues have questions? I have just one, but
Thank you. One very quick question, a very particular and very quick question, Professor. And in the interest of time, I'd ask you to try and answer it as specifically and as quickly as possible. At paragraph 20 of your second report, you refer to the nemo turpitudinem principle, what some of us might call the nemo dat principle, or poor English speakers, the principle that one may not be heard to invoke his own turpitude, correct? That is one element of your critique of what the courts have done here. If one looks, however, at R63, which we saw earlier, at page 6, could I ask the technician to turn that up? For the benefit of the witness in particular on the screen. I have it on my own screen. Right, page 6. Fifth paragraph. It begins in English, nonetheless. Could you highlight that, please? Professor, you see the paragraph. I know you might not see the Slovak version. There it is, but I understand you read English. When I read this several weeks ago, it occurred to me that this is the court's attempt, in fact, to balance rights and to consider the fact that Ms. Varyanova ought not to have obstructed this access road. Do you agree with me?
Yes.
Very principle that you say they ignored.
Well, at the same time, thank you, Madam President, for the argument. A simple answer is yes. And it says even here that it was an access road. So as though the court agrees with the fact that this is an access road and it was not appropriate to block it.
Right. So the court did, if you will, consider whether, or attempt to consider, or commence to consider whether or not Ms. Varyanova acted contrary to the law and took that into consideration in its judgment. It seems to me.
Of course, it is a very legitimate legal impression. But let me emphasize, it is still a resolution on granting preliminary injunction, where the court does not exercise evidencing. In fact, you do not evidence, you only certify fact. And semantically appropriate to that is the careful language of the court in its documents, in its judgment, pointing out that this could be a problem since they have not conducted evidencing, they have no authority to provide more detail or more depth. This is how I would read it. But in principle, one cannot disagree with what you just said.
That was my sole question. The rest has been very comprehensively covered by council and by previous questions that we've asked you. Merci, madame.
Professor Stefchak, I would simply like to make sure that I understood you correctly. At 13:07 approximately, and I'm saying this for reference for the transcript, you should not concern you. You were calling for more legal certainty in Slovakia. And you then said who else would have the power to decide whether or not this road is a special purpose road, if not either the Ministry of Transport, and then you referred to the basis for its powers, and the municipality of Smilno, and you also referred to the basis for the power. Is that, do I understand you correctly? It's the ministry, and you explained that this is not a binding interpretation, but still it has the competence to give it, and the municipality.
Ano?
Yes, but neither one of those two are binding. But in this case, not even the court interpretation is binding. And that's absurd. Court's interpretation is only absurd inter partes in this particular case. But in order for this issue to be resolved once and for all, I think it should be in the power by bodies of public power different than court. For instance, Ministry of Transport should issue a methodological guidelines, no matter how unbinding, but it would bring much more light into this area, while the court, no matter how high or superior it is to protection of legality, may not issue any generally binding guidelines, only mediates inter partes case. This is what I had in mind.
Thank you.
Sorry,
I think you've clarified that.
could I just raise one point on the transcript? I think at 13:17:24, the reference is absurd. I think I heard observed. Is that correct? It's just maybe an interpretation.
I heard absurd,
He said absurd.
Absurd.
but we can ask him.
Yes, indeed. I heard.
Well, I mean, yeah. Can the interpreter back?
I'm sorry, I don't remember. I would have to make familiar with the context of the sentence.
The interpreter could refer back to the word that was used then and ask in Slovak what word was used and then translate it back to us.
We don't remember exactly, but I have no doubt about this. I guess I have used this word. If I meant the situation of the state of law or rule of law in Slovakia, I think it would be a quite appropriate word. Now, the comment by interpreter, if I may, the interpreter remembers a word absurd has been used.
Thank you.
Thank you.
Professor Stefchak, this was a long examination, but we're now getting at to the close of it. So we would like to thank you very much for your assistance this morning. And that ends, we can now disconnect the connection.
I'd also like to thank you very much for your patience. It's been very beneficial to me as a professional experience. So I equally thank you and wish you a nice day. Goodbye.
Hi, thank you. This is obviously a good time for us to break, but I should say that we were a little concerned by the time that was taken for the cross examination. Of course, on both sides, you know that you're in charge of the allocation of your time, and there will be no time for extensions. I think we've been clear about that, and that is what it will be.
We certainly understand, Madam President.
Excellent. Then have a good lunch, everyone. Should we be back at 2:15?
That would
Is
be
that
fine.
fine? Good. Good afternoon. Although you have been with us this morning already. Do you have interpretation?
Yes, I can hear it well, Madam President.
Can you please confirm that you're Amir Fogash?
Yes, I am.
You are a practicing attorney. You have also taught civil law as a professor.
Yes, this is true.
You have submitted two expert reports, the first one of 31 March 2023 and the second one of 11 December 2023.
Yes, indeed, that is correct.
You're heard as an expert in this arbitration. As an expert, you're under to make all the statements in accordance with your sincere belief. Can you please state this by reading the expert declaration?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Can I turn to you first, Dr. Prakash?
Thank you, Madam President. We have no questions.
Good. Then that was fast. Mr. Tushingham.
Thank you very much, Madam President. Dr. Fogas, good afternoon.
Thank you, the same to you.
Would you prefer if I refer to you as Dr. Fogas or Sir? What would be your preference?
I leave it fully up to you. Both is pleasant.
Thank you very much. I was reading through your CV and I wanted to just ask some very brief questions about your background. As I understand it, you obtained your doctorate in law in 1976. Is that right?
Yes, that is correct.
In 1985, you then became an associated professor of civil law at PF UK. Is that right?
Yes.
And then I also read with interest that between 1990 and 2002, you spent 12 years as an elected politician in the Slovak Republic. Is that correct?
Yes, that is correct.
In both the National Council and then also as a Deputy Prime Minister of the government for legislation. Is that correct?
Yes, this period covers both mandates when I was part of the Supreme Constitutional authorities or elected positions.
And do you accept, therefore, that as a result of your 12-year career in politics, you have a past affiliation with the respondent in this arbitration?
After 12 years in politics, I came to the conclusion that Slovak legal order is fully adaptable and adapted to the conditions of the European Union law, and I have decided to return back to my former profession.
I understand. And as I understand it, after you retired from politics, you then became an attorney at law and later a professor at PF UK.
Áno, vrátil som.
Yes, I have returned back to my alma mater, and I have taken over the Department of Civil Law as the head of the department.
And is it correct that since 2017, you have not held any academic position at that university? Is that right?
Áno, je to tak.
Yes, that is correct.
Thank you. I would like to begin, if I may, by looking at the conditions for granting an interim injunction under Slovak law. Could I ask that you be shown exhibit LF4, and in the English it is page 22, and in the Slovak it should be page 15. Sorry, so in the English, it should be page 22, not article 22. Yes, and in the Slovak, it should be page 15. Sir, do you see Article 74 of the Code of Civil Procedure, CCP, on the screen?
Áno,
Yes, I can see that.
And that provision, as I understand it, empowers the court to grant an interim injunction before proceedings are initiated. Is that correct?
áno, je to tak. Občiansky súd.
Yes, that is correct. This was the possibility to a higher degree of flexibility in the Code of Civil Procedure to impose an interim injunction before the proceedings, or at the same time as the proceedings have begun, or during the course of proceedings.
Could you please move forward to Article 102, which should be at page 37 of the English and page 26 of the Slovak? And if we could scroll down to the bottom, Article 102. We could scroll down in the English just slightly, please. Yes. And is it correct that Article 102 is the provision which empowers the court to grant an interim injunction after proceedings have been initiated?
Áno.
Yes.
And in the present case, is it correct that Ms. Varianova relied on Article 102 in her request for an interim injunction, which was filed in January of 2016?
Áno.
Yes. Now, I hope this is going to be uncontroversial, but would you agree that Ms. Varianova's substantive action was for a declaration nullifying a purchase contract which AOG had concluded with Mr. Tomacek in December of 2015?
Áno, týkalo sa to.
Yes, this referred to an action with the purpose of declaring a nullity of such an agreement.
Yes, and in that regard, Ms. Varianova relied upon provisions in the Civil Code, specifically Article 40A and Article 144. Do you recall that?
Ještě raz prosím tu otázku.
If you could please repeat the question again.
Perhaps I could just show you, it might be easier by reference to your first expert report at paragraph 14. That's the second expert report, I'm afraid. It's the first expert report. You see in paragraph 14, you refer to the action, which had its substantive law basis in private law under the Civil Code, and you refer to Article 40A and 140 of the Civil Code. Do you see that?
Ano, vidím.
Yes, I can see that.
And on the same day that Ms. Varianova initiated her substantive action, she also filed a request for an interim injunction against AOG. And you refer to that in paragraph 15.
Ano.
Yes.
Do you agree that Ms. Varianova's claim for substantive relief, nullifying the purchase contract, did not automatically entitle her to obtain an interim injunction restraining AOG from using the land plot?
Myslím si, že
I believe that the procedure was such that the request for interim injunction was submitted, and as a follow-up, I don't know whether this was the case of days or week. Apologies. So first the action was submitted, and then the request for granting the interim injunction was submitted.
Yes. My question is just slightly different, which is, do you agree that the claim for substantive relief that Ms. Varianova was seeking to obtain in her action did not automatically give her an entitlement to request an interim injunction? She needed to satisfy additional conditions in order to obtain an interim injunction. Do you agree?
zákon stanovoval,
The Act clearly promulgated the conditions under which the request for an interim injunction can be submitted, and I'm deeply convinced that these conditions were fulfilled at that time.
Could you please be shown exhibit MS5? And in the Slovak, it's page 4. In the English, it's page 1. This, as I understand it, sir, is Ms. Varianova's request for an interim injunction. Do you see that?
Objection,
Ano.
mischaracterization. The document is both the claim and the request.
That's entirely fair. I will rephrase. This part of the document is the request for an interim injunction. Do you agree?
ano.
Yes, I do.
And you can see that Ms. Varianova relies on Article 102 of the Civil Code, or a Code of Civil Procedure. Do you see that?
OSP. Ano.
Yes, I do.
So if, in order to obtain an injunction, Ms. Varianova needed to establish that there was a substantiated need temporarily to adjust the situation of the parties under Article 102, subpara 1. Do you agree?
Ale myslím, že to urobila. I think that's what she did.
Have you seen this document before, sir?
Áno.
Yes, I have.
By contrast, if there is no substantiated need temporarily to adjust the situation of the parties, do you agree that, hypothetically speaking, the court cannot grant an interim injunction under Article 102?
Išlo o
This was the issue of a dispute between co-owners, and the immediate injunction is a measure of securing, guaranteeing of a situation where during the course of the dispute or before a ruling is made, rights of one of the parties shall not be violated. So I believe this is a common practice.
Perhaps you could just be shown your first expert report, please, at paragraph 29. Do you have that in front of you?
Nemám.
In print?
At paragraph 29.
Áno.
Yes.
To je druhý posudok. To, čo mám pred sebou.
What I have in front of me is my second expert assessment, and I insisted on the fact that the court should have considered the nature of the landlord. This is the text of the second expert assessment.
Perhaps if you could do it by reference to the document that is on the screen, sir.
Áno.
that is- you have it there. Do you have paragraph 29 in hard copy in your first expert report? Do you have
Áno.
that in front of you? Yes. And
Áno.
the sentence which begins, such situation occurs if there is a substantiated need temporarily to regulate legal relationships of the parties due to a threat of damage and or increase of damage. And as I understand it, you are referring there to Article 102, subpara 1 of the CCP.
Áno.
Yes.
So if there is no substantiated need, hypothetically speaking, temporarily to adjust the situation of the parties, the court cannot grant an interim injunction. Do you agree?
Samozrejme.
Well, yes, because the condition for issuing the immediate injunction needs to satisfy certain conditions first.
Thank you. Could you go back now, please, to exhibit LF4 and go, if we move on to Article 75 of the Civil Code, which is at page 22 of LF4 in the English and page 15 in the Slovak. So it's page 22 in English of LF4 and page 15 in the Slovak. I don't think we have the right document
No.
on the screen.
Yeah,
So
it's a witness statement.
it's an exhibit to Dr. Fogas's expert report, exhibit LF4. Yeah, that's it, exactly. Great. And if we could just scroll down slightly on the Slovak. Dr. Fogas, do you see Article 75 of the CCP on the screen in front of you? So do you see in Article 75(1), it provides that an interim injunction shall be ordered by the court upon a petition. And then 75(2) provides that the petition shall include, and then the words that I'm interested in are the reasoning of the risk of imminent harm. Do you see those words, imminent harm?
Môžem ten paragraf vidět?
Could I please see the whole text of the article, because I can only see the first half of it in the Slovak version.
Ano?
Yes?
Yes. And do you recall Professor Stevchek's opinion in his expert reports that the words imminent harm mean that the applicant must certify that without the injunction, significant, serious, and even irreparable harm could occur? Do you recall his testimony or his opinion in that regard?
Ano.
Yes.
And in your first expert report at paragraph 37, do you recall saying that Professor Stevchek did not provide any court decision that would properly justify that conclusion? Do you recall your opinion in that regard?
Pýtate sa na...
You are asking at a different issue. In point 37 of my expert report, I debate with Mr. Stevchek the case whether the imminent or irreplaceable or other type of harm is to arise. This is something totally different than what your question aims at.
Well, as I understood it from
To je
paragraph
36 potom.
I suppose then you refer to point 36 of my expert report.
I'm looking at paragraph 37, where you say
Ano?
Yes.
provide any reference to any provision of the CCP, any professional literature, or any court decision that would properly justify that conclusion. And what Professor Stevchek is discussing there is the concept of imminent harm. That's right, isn't it?
Zákon.
The act at the time when the court proceedings were held included wording that one of the conditions for imposing the immediate injunction is the imminent harm, not as Professor Stevchek has stated, where he claims that serious, significant, or even irreparable harm can occur. In my expert assessment, expert report, I referred to the single document which has been written in Slovakia regarding these remedies. This was a book by Professor Mazak, the former president of the Constitutional Court, at the moment the head of the Judicial Council of Slovakia, where in his book he characterizes the conditions for issuing the immediate injunction. This is also stipulated in my report. It says that the risk of imminent harm, not serious, irreparable, or significant harm. So I cannot consider such conclusion as a correct one.
Could you please be shown exhibit MS-2? In the Slovak, it is on page 4. Perhaps if we just start these on page 1 of the Slovak, in fairness. So this is a resolution of the Supreme Court of the Slovak Republic dated the 12th of May, 2012. as I understand it. Have you seen this resolution of the Supreme Court before?
Neviem, či som ho...
I don't know if I have seen it, but I think I know it.
Could you please turn to page 4 of the Slovak and the highlighted passage? And in this passage of the Supreme Court's resolution, the court says it follows from the provisions of Article 75, para 2, governing requirements of a motion for an interim injunction, that one of the preconditions for granting the injunction is that the applicant justifies the threat of imminent harm. This means that the applicant must certify that without an injunction, significant, serious, and even irreparable harm could be caused to the applicant. Do you see that?
Vidím.
Yes, I can see that.
The Supreme Court is the highest court in the Slovak Republic in the hierarchy of the courts. Is that right?
Je to tak.
It is so.
And so this decision supports Professor Stevček's opinion as to the meaning of the words imminent harm in Article 75, subparagraph 2 of the CCP. Do you agree?
Nesúhlasím.
I don't agree. Professor Stevček himself stated in his testimony today that the rulings of the court are not binding. This is the first thing. The second thing, that this case law of the Supreme Court was never generalized, meaning that the Supreme Court issuing its collection of case law in which it publishes the most relevant and binding findings, which are to complement the reading of law, or which are to instruct courts on the level on how to rule in civic cases, in civic disputes. This case law has never been published. Above all, it's from 2012, nor has it become a basis or a precedence for ruling of lower courts. The reality is such that the new wording of the Civil Procedure Code does not even include parts referring to such imminent harm. So even in the period from which this document originates, it couldn't have been generalized for all courts in Slovakia ruling on similar cases, because they, first of all, might have not been familiar with it, as it has not been published in the collection of rulings of the Supreme Court.
Could you please be shown exhibit MS3? As I understand it, this judgment or resolution of the Supreme Court dated the 29th of April 2011. Have you seen a copy of this resolution before?
Nevidel, ale...
I have not seen it, but I've heard about it.
Could you please turn to page 8 in the Slovak? And again, here we see exactly the same language being used by the Supreme Court as in the earlier decision that we saw just before, don't we?
Nie je to celkom...
It's not exactly the same wording, but it is a similar wording, and it is from the same period. Nor this case law has ever been published in the collection of rulings and opinions of the Supreme Court of the Slovak Republic. Therefore, it has not become a basis for the ruling of courts in Slovakia. The practice has always been such that the part of ruling has used one legal sentence to be published, which then included also a detailed commentary, which helped the courts in their rulings. None of the case laws, none of the rulings that you have shown to me have ever been published in such a collection. Therefore, it has never become the basis for ruling of lower courts in Slovakia, since these readings have not been adopted in practice. The current wording of the law does not include any reference to it.
Doctor, if I may, I'm not trying to put any formal characterization on these legal texts. All right, we haven't discussed it. We're not there yet. But on their face, they stand for the proposition that an applicant for this sort of injunction must certify that absent the injunction, significant, I'm quoting, significant, serious, and even irreparable harm could occur. I understand your point that these particular judgments, for various reasons, have not formed part of the body of law applicable to lower courts. I understand your comments on that. But are you telling us that this proposition regarding the need for significant, serious, and even irreparable harm is not a proposition known to Slovak law related to this sort of injunction at all?
Tá konštrukt
The construction of the procedural code, whether this has been the CPC or CCP, so whether this is Civil Procedure Code or Code of Civil Procedure, is such that we need to immediately resolve the relations between the parties. All literature which is being published on this, including case law, stipulates that before an immediate measure injunction is ordered, no other examining is ordered other than those that was present in paper form together with the action to the court. So at that point, it is not even possible to settle what is an imminent or significant or even irreparable harm. At that time, it is not possible to define that. My opinion, my personal opinion, is such that the original law, which stated that we need to first of all demonstrate at least a significant or imminent harm, any form of imminent harm, that was a more correct wording than the present wording, which doesn't refer to any such harm. I believe that our Civil Procedure Code has been in practice for a rather short period of time, and we will definitely see its amendment. And this will be one of the issues addressed. Namely, to conclude, I'd like to state that it shouldn't refer to serious or even irreparable harm. I wouldn't say that this should be in the present wording, because this would need to be proven. This would need to be proven, but referring to imminent harm is something I could live with. But as I've said, today we have no such references there.
Right. Even imminence would need to be proven, though. I suppose that's a factual question.
Myslím si, že
I believe that if I understand the broad scope of civil proceedings, sometimes it is sufficient for the harm for the threat of the harm to loom. It doesn't have to be characterized by a certain scope or size. For example, when we talk about minors, or when we talk about payment of damages, or when we talk about disputes between co-owners, as is this one. In any case, the longer the illegal state were to continue, for example, an invalid agreement, the higher the harm, the higher the damage. Therefore, I think that the referral to a harm had its place in the wording of the law. But as I have said, there was no, this was not the degree of the harm to be demonstrated, because at the time when the court is ruling, we need to consider the real situation. An action is submitted. Even if you submit the proposal for the immediate injunction a week after, it's still an insufficient amount of time for court to examine the individual evidence, because this requires an immediate action on the side of the court, whether this is meant to protect the ownership or a child or a legal capacity or any basic rights of citizens.
prosím.
Sorry, sir, thank you very much. Could you please be showed now exhibit MS4? And as I understand it, this is a extract from a textbook edited by authors including Professor Stevchek entitled The Code of Civil Procedure, published in 2012. Have you seen an extract or this extract before?
Neviem, ktorý konkrétny.
I don't know which specific text you refer to, but I know the textbook, yes, of course.
Could the right-hand side of the screen, could you just scroll down to the bottom, please? And do you see in the highlighted passage there, could you just read that to yourself, please?
Mám to prečítané.
Yes, I've read that.
To je citácia jedno.
This refers to one of the rulings of the Supreme Court. Nevertheless, probably the same one. The author is a member of the department who is the single one, or she has been left alone with this legal opinion. At the same time, I'd like to state that no other commentary during the validity of the Code of Civil Procedure since 60s until 2012, no other ruling has ever had such a commentary, whether this was the author of the former Code of Civil Procedure, Mr. Rubesh, or other following scholars like Madame Winterova, or for example, Mr. Češka, or other professors would ever provide a similar commentary who were leading authors on the issues. And nevertheless, all of us, or most of us, have contributed to writing these academic papers. This is an isolated academic opinion.
But do you agree, sir, that Professor Stevchek and the other authors of this, editors of this textbook, are authoritative figures in the field of civil procedure?
Myslím, že
I think that the freedom of investigation of scientific inquiry is guaranteed in Slovakia. Everyone is entitled to his or her own opinion. Every single book that I've wrote included proposals to amend and to expand the legislation. So I fully understand that my colleague, who, if she was the author of this part, she came with a certain proposal, which in my opinion would complicate the imposing of immediate injunctions, because it would significantly reduce the possibility of protecting basic rights. And that's why this has not been adopted in our civil law.
Sir, I would like you to assume in my favor, for the purposes of this discussion, that an applicant must certify that without an injunction, significant, serious, and even irreparable harm could occur. I would like you to make that assumption for the purposes of this question. Assume that there is a dispute between a plaintiff and a defendant about who is the owner of a priceless painting. And assume that the defendant has threatened to physically destroy the painting. You would agree with me that that would provide evidence of significant, serious, and even irreparable harm. Do you agree?
poviem to úprimne.
Speaking honestly, this measure in the civil law is to provide a fast method of protection, irrespective of whether we are talking about a priceless painting or a less valuable painting. It can still have an exceptional value to the owner. For example, this can be painted by the father or a brother of the owner, or someone to whom this painting will commemorate and remind the personality to eternity. And it would be very difficult, apart from specific material estimate, it would be very difficult for us to estimate what does it mean for a specific person. In case of a piece of art which has which is from a known author, it could probably be possible to have a specific number, to put a price tag on that. But in that case, for different parties, the different parties to the dispute would have different weapons. Someone would be asked to demonstrate more, someone would be asked to demonstrate less. And the court, even in civil disputes, especially in ownership disputes, the court is expected to provide the same level of protection, irrespective of whether we are talking about valuable or less valuable things, if these items have other values that cannot be accounted for or that cannot be defined at that particular moment. So even for the future, to define that there is a significant, serious, or possibly even irreparable harm, that would require a totally different approach to immediate injunctions, and from the very outset, admit a certain evidencing. That, however, is not admitted or not considered in our civil code. The Constitution and even the Bill of Rights, even the international conventions on human rights, they protect life and also ownership. Protection of life cannot depend from the fact that whether we are protecting a rich or poor individual. Protecting ownership also cannot depend from protecting a vast fortune or a small fortune, small property. The protection has to be provided immediately and also to the best extent possible in order to avoid future damages, future harms. If this is to happen, if this is to be safeguarded, we have the immediate injunction, which is of a temporary nature only. And practically, it always lasts only until the valid court ruling of the case, only until justice is being served. If we consider the rulings of the courts something that philosophically embodies justice in society.
Dr. Fergus, we have a limited amount of time this afternoon, and I would appreciate it if you could just to listen carefully to my question and try and keep your answers succinct. I'm going to change the hypothetical now. Assume that the dispute before the court relates to the right to use a land plot, talking about real property here. Unless the defendant has made a threat that results relating to the physical condition of the land plot, the condition in Article 75(2) of the CCP will not be satisfied because there is no risk of either imminent harm or irreparable harm to the land plot itself. Do you agree?
Znova opakujem again, I repeat that the law doesn't require the presence of a significant, serious, or even irreparable harm to be present. The law says that at a given point in time, the valid Code of Civil Procedure stated that we need to demonstrate imminent harm. If you want me to respond to the degree of protection to the land parcel, I believe that every time when a land parcel is being used by someone who is not entitled to it, whose ownership rights are at least dubious given the fact that an action has been submitted, it is right and proper to make sure that no harm is done on that given land lot.
Sir,
And an injunction might serve to prevent such imminent harm, you would say.
Máte absolútnu pravdu.
You are perfectly right. This is what all such measures in civil dispute law are for.
Sir, in the answer that you just gave prior to Mr. Dreimer's question, you said, I believe that every time when a land parcel is used by someone who is not entitled to it, whose ownership rights are at least dubious, do you agree with me that as at the date of the decisions by the Bardejov District Court and the Prešov Regional Court, there had been no final ruling on the merits about the validity or invalidity of the purchase contract between AOG and Mr. Tomacek?
Rozhodnutie vo
The ruling on the merit is a ruling which is conducted only once evidence is being examined. After all the individual procedural steps are taken, the immediate injunction is issued for the interest of safeguarding the rights of the party whose rights are to be protected before the evidence is being examined. So yes, at the time when the immediate injunction has been issued, there doesn't have to be a final ruling on the case on the merit. If there would be a ruling on the merit, such immediate injunction would be useless.
And in her request for an injunction that we looked at earlier, Ms. Varianova advanced two separate claims for relief. The first was an order against AOG an order requiring AOG to refrain from the land plot itself. And the second was an order requiring AOG to refrain from removing things placed on the land plot by Ms. Varianova. Do you agree?
Myslím si, že
I believe that the immediate injunction aimed towards preventing the use of a piece of real estate that has been characterized as an arable land.
Could we just look then, please, at the request, which is a MS5? And on to page 2 of the English, please. And in the Slovak, we could turn to page 4. So do you see on the page there that the plaintiff claims the court to order this interim injunction, and there were two prayers for relief. The first, that the defendant is obliged to refrain from using the real property, and that's what you've referred to as the land plot in your reports. Is that right?
áno.
Yes.
And the second, in the second paragraph, was an order that the first defendant be obliged to refrain from removing things placed by the plaintiff on the property, on the land plot. Do you agree?
Áno.
Yes.
So unless there was a risk of imminent harm to the land plot itself, in other words, the physical condition of the land plot, the condition in Article 75(2) of the CCP would not be satisfied. Do you agree?
Ak by nehr...
If there was no imminent harm, I would agree, yes, that the conditions would not be there.
Pýtate sa toho.
You are asking a theoretical question here.
Well, it's not entirely theoretical, sir, because if you look back at the request on the previous page,
Áno.
and in the English as well, please. I'm going to suggest to you that the only evidence that was before the court related to a threat of damage to the motor vehicle. There was no evidence of a threat of imminent harm to the land plot itself. In other words, the physical condition of the land plot. Do you agree?
Ale taký dôkazaný...
But such an evidence had no need to be submitted. There was no need to submit anything like that. That could have been submitted in the proceedings on the merit.
But in order to obtain an injunction restraining AOG from using the land plot, Ms. Varianova needed to certify that there was a risk of imminent harm to the land plot itself. Don't you agree?
Myslím si...
Well, I ask for forgiveness for a slightly longer intervention, but if the land lot was used, for example, by heavy machinery, if it was to be used by such vehicles without the adoption of necessary measures, a possible damage and threat, harm to the landlord could occur. The court had the possibility to ascertain and to consider whether damage, whether harm is present to the whole landlord, to the whole piece of real estate, or only to the items which are placed on the landlord.
Do you see any reference in the request, though, to any evidence of damage to the physical condition of the land plot by heavy machinery?
Myslím si, že súd má
I believe that the court needs to consider the whole proposal as such, and in the broader context, and this is only my theoretical consideration, that it came to the conclusion that as it relates to the protection of ownership rights, because this was a dispute between co-owners, the real estate itself has to be protected as well.
That, I'm afraid I'm going to have to ask my question again. Is there any reference in the request to evidence of damage or a risk of damage to the physical condition of the land plot?
Ja si myslím, že v tej žalobe
I think that in the action describes the situation on the ground to a sufficient degree for the court to come to a conclusion, even for a formulation of the immediate injunction. From the text that you have submitted to me, it also stems that, as it is referred to in the letter of Dr. Slamka, the defendant, since its entry of its ownership into the cadastre, has been asking for actions on the side of the plaintiff, which is to respect his or her ownership on the land parcel, which basically says that on the basis of a purchase contract, I am the owner and I can use the landlord in any way I see fit. The ownership right or the use right, the rights of use to the landlord are determined from the ownership right. It's basically defined by the ownership title to the land. Therefore, I think that the description of the situation on site is sufficient for the court.
Are you suggesting, Doctor? No, I won't be so coy. My understanding of your testimony earlier was that anytime a person who is not entitled to a parcel of land threatens to enter onto that parcel of land, there is a risk of imminent harm to that land that can be enjoined?
áno, potenciálna náhrada.
Yes, there is a potential harm, potential threat.
And is that an imminent harm in your view, such as might allow for a temporary injunction or interim injunction of this sort?
Ak takáto
If such person, which is not in legal standing, whose ownership title is dubious, enters such a land lot, for example, it would park its vehicles there, it would, I don't know, carry out certain activities on the land lot, there is a threat of, there's a threat to the land lot itself. So there is a possible harm.
So is the nature of the trespassers trespassing relevant? Does it matter if he parks a car or drives heavy machinery or just purports to go walking on it? Does that have any impact on the court's consideration of an interim injunction?
myslím, že
I believe that what needs to be considered is the specific situation, the specific case individually, case by case. At the same time, what we need to consider is the length and mode of use of that given land lot. Imagine that someone becomes an owner of a garden without legal title. For example, you cut the trees and you replace them with new ones. Or, for example, you proceed with other steps. You start to carry out other steps which can, in his or her opinion, be oriented towards future. It can be for the benefit of the future. But the original owner, who is entitled, who was either bypassed or tricked or in any other way, his ownership rights remain, he may not wish for such actions, and there is a potential of harm. We always need to consider this special situation or the cases case by case, and the court is entitled to adopt its own assessment and to adopt a ruling on a basis of its own understanding of the situation and assess the potential for the imminent harm.
Thank you, Dr. Sir. I'm going to move to a slightly different aspect of the injunction now. So, do you agree with me that in deciding whether there is a need temporarily to adjust the situation of the parties, and I'm thinking back to Article 102, subparagraph 1, do you agree the court must consider whether disproportionate damage would be caused to one of the parties as a result of the granting of the interim injunction?
Ještě raz poprosím tu
Could you please repeat the question again? Should I agree with?
Yes, I will repeat again. Do you agree that in abstract terms, in deciding whether or not to grant an interim injunction, the court must consider whether disproportionate damage would be caused to one of the parties, for example, the defendant, as a result of the grant of the injunction?
zákon
The law had these situations in mind, and in one of the stipulations, it obliges the proponent of the immediate injunction in cases where such immediate injunction has not been had not a legal standing, has been improper one, to compensate for the damages. So yes, the defendant is protected. In the end, the damages will be compensated. The plaintiff is not the one who is protected. So the court has to also consider all issues, all matters at hand. Quite clearly, we have provided for the protection of the defendant by means of the stipulations regarding the compensation of damages. Even the defendant is protected in a way that even if an immediate injunction is quashed, even if the defendant wins the trial and the action is refused, even in such cases, he or she is entitled for compensation of damages. Therefore, in a situation when the court is to rule, all these issues are to be considered and the ruling has to be done in line with the law. And I believe that an impartial judge will do so.
Could you please be shown Exhibit C125? And it should be page 7 of both the English and the Slovak. This is the decision of the body of district court in the injunction proceedings. And it's page 7. And do you see the top paragraph there that begins, the preliminary measure is admissible and justified if, and then E, the legal relations between the parties are not interfered with in an unreasonable manner. The court must consider whether, as a result of the preliminary measure, disproportionate damage will be caused to one of the parties to the proceedings. Do you see that?
Áno.
Yes, I can see it.
And this is a decision that you say was justified. So you must agree that the court must consider that in deciding whether to grant an injunction. Do you agree?
Vy ste sa ma
A while ago, you asked a question relating to a painting and whether we can define what degree of protection should be provided by the court. Well, to perhaps explain my position, I'd like to use a similar situation. If we had a painting, the immediate injunction, in order to prevent any further limitations to its use, I would forbid any further sale of the painting, and I would order for it to be stored somewhere safe in order not to have any damage on it. In such way, I would protect both parties to the dispute. And I would also consider the fact that I will not be causing an irreparable situation. The painting would continue to exist, it would be protected, and in the meantime, the parties would sue who is the true owner of the painting. In this line, I would also read the text that you have just highlighted to me.
Do you agree that in considering whether disproportionate damage would be caused to one of the parties to the proceedings, the court consider a wide range of circumstances, including the size and monetary value of the property, whether the injunction might prevent the defendant from carrying on its business, whether the defendant's business activities are in the public interest, factors of this kind? Do you agree that those would be relevant to the assessment of disproportionality?
Souhlasím.
I agree with you that the court needs to assess all aspects. However, as I have said, ownership is protected from the Convention on Basic Human Rights all the way through the Constitution and specific laws, as is the case in Slovakia, and I would not reduce it to wealth. I would rather instead link it to measures that would prevent the arising of damages to one or the other party in a adequate manner, and at the same time I need to protect the owner. So in this I mean in order to protect the owner from actions of the other side, meaning the side which is not which is acting illegally.
Well, do you also agree that in the court's consideration of those aspects, the court should consider whether alternative relief, short of an injunction, would be more proportionate? For example, an order for monetary compensation rather than a prohibition on the use of the property.
Máte na mysli prípad, ktorý je predmetom
I think you refer to, are you referring to a case which is subject to the considerations of this tribunal? Or are you talking in general?
Well, I'm referring to this specific case, and I'm only just going to ask you this. It appears from the district court's judgment that the court did not consider whether disproportionate damage would be caused to AOG's business activities by the grant of this injunction. Do you agree?
Na túto otázku.
I don't think I can answer this question because I cannot see the inside the heads of the judges what everything was considered in their ruling. On the other hand, if you are referring to 1 C-29 2016, what we also need to take into consideration is that whose right is superior, whether the right of those who have illegally acquired a certain item, as was the case here, or whether we are talking about protecting the right of the potential owner, who clearly, according to the law, is entitled to his or her rights. This is what you can see from this action on, who is on a firm legal standing, because the invalidity of the agreement has been underlined, and since this was an invalid contract, it was quite clear that in the end, the purchase agreement will be nullified, will be invalid. Therefore, to respond to a question whether the court was to protect more the interests of AOG or should have leaned more towards protecting the rights of Madame Varianova, I mean, we cannot provide you with a single clear answer. I'm not a judge. If I was a judge, I would definitely protect the owner, the one whose ownership rights are at risk, to a higher degree at least.
Proportionality an element of the law on this point? Is a court obliged to consider what in the common law and certain civil law jurisdictions would be called the balance of inconveniences?
Áno,
Yes, there are situations when the court needs to consider this, but this was not the case.
In the context of this sort of interim injunction, is that what you're telling us?
nie.
Thank you.
Aha.
No.
No, I'm right, or no, I'm wrong?
Mám pravdu určite.
I'm correct simply because in this case, it is impossible to provide any other form of protection for the real estate other than preventing its use. What other possible remedy do we have?
Well, another possible remedy, sir, would be an order for the payment of damages if it is later found that the land has been wrongfully used. Do you agree?
Ak by bolo, ak by nastala taká situácia,
If there was a situation where the court would rule too late in the case, there would be a delayed ruling. I can imagine that together with ruling on the ownership, a certain compensation of damages would be also implied. That would, for example, include a calculation of rental fees for the period over which the piece of real estate has been used wrongfully, or without a legal title. But we still need to return back to this stipulation that in the meantime, the piece of real estate can be damaged to such a degree, or its character can be changed, or its value can be reduced, that such situation can be irreparable. And there is no other way of preventing that other than creating or adopting a means of safeguarding, such as this immediate injunction.
So are you accepting there, sir, that the damage needs to be irreparable?
to som nepovedal.
Never said that. I never said that. You asked whether other compensation is permissible, and I replied that if there was no immediate injunction and the piece of real estate would be used until the decision on the merit of the case, the court could also oblige to pay a certain compensation. This was not the case because the immediate injunction has been stipulated. However, in no case have I said that the condition of irreparable or significant harm needs to be satisfied first. Here, the only thing that had to be satisfied was the imminent harm.
Into a new topic now. Sir, unless I am mistaken, in your two expert reports, you do not express any opinion either way about whether a field road is a type of special purpose road within the meaning of the Road Act. Have I understood your expert reports correctly on that point?
Takto vo vzťahu k môjmu znaleckému
In relation to my expert reports, I was never given this question. I can comment only in general terms.
I'm going to now turn to the question of jurisdiction of the court to grant an injunction, and this will be my final topic. I want to try and see if you agree with some basic points with me in relation to the court's jurisdiction. First of all, do you agree with me that jurisdiction is one of the conditions for the conduct of a court proceeding?
proces
Civil cases are administered by a specific set of conditions, and one of them is also the jurisdiction of the court. That's what that's what I think you refer to, the jurisdiction of the court.
Exactly, sir. My second question is, do you agree that under Article 103 of the Code of Civil Procedure, a court must constantly monitor whether it has jurisdiction?
Áno, právomoc súdu
Yes, the jurisdiction of the court has to be continuously examined throughout the proceedings.
And that examination has to be undertaken by the court itself. Do you agree?
nedostatok právo
The lack of jurisdiction can be underlined or pointed by one of the parties to the dispute. Yes, but this is also one of the ex officio obligations of the court.
And this ex officio obligation applies at all stages of proceedings, including when a party applies for an interim injunction. Do you agree?
áno, tomuto
Yes, I'm convinced about that.
And the issue of whether a court has jurisdiction is a question of law. Do you agree?
Would you please repeat, because we couldn't understand the last part of your question. If you could please rephrase that.
I'm sorry, I'll try and rephrase. The question of whether a court has jurisdiction over a particular dispute is a question of law. Do you agree?
áno, ide o procesný
Yes, this is a procedural problem.
And if the court concludes it does not have jurisdiction, it must terminate the proceedings under Article 104 of the CCP. Is that right?
Ak nastane
If there is a situation that it is established that the court does not have jurisdiction or loses its jurisdiction, yes, in such case, the proceedings have to be stopped, and it has to be submitted to the responsible or corresponding authority.
Do you agree with Professor Stevček that the Jura Novit Curia principle forms part of Slovak law?
to je stará rímska. To je stará rímska zásada.
It's an ancient Roman principle, and I think it's respected in all legal orders, including the Slovak one.
And so that principle means that in legal proceedings, parties are not required to prove the contents of a law published in the collection of laws of the Republic. Is that right?
Apologies, I hear that the translation was not done properly, so please repeat your question.
Of course. In a legal proceeding, a party is not required to prove the contents of a law that has been published in the collection of laws of the Slovak Republic.
Teraz som
Well, I don't know if I understood the question properly. If I could ask you for the third rendition, because we've grasped only half of it.
Is, does a party have to prove the content of the law like you would prove the facts of one's case? This is a question asked by a common law lawyer, because for civil law lawyers, in principle, we do not prove the law, and that is probably the difficulty in the question.
strana musí
A party to the dispute needs to describe the case, and it needs to formulate its request for relief. So what the party is asking for, and the request for relief is the defining for every further step of the proceedings, including the jurisdiction of the court, if the request for relief is formulated as it aims towards protection of public interests, for example, well, in such case, the submission to the court might not be successful. However, in principle, it applies that the citizen doesn't need to be familiar with the articles and the law. This is what the court should be familiar with.
And so do you agree that at the time when the body of district court and the Prešov regional court issued their judgments in 2016, they should be familiar with the contents of the Road Act statute?
Ak som pozorne preštudoval,
If I understood the submitted documents well, Madame Varyanova has been asking for the protection of her co-ownership rights. This was a dispute between two co-owners. Precisely, this was the validity or invalidity of a purchase agreement, which was concluded without her being offering the rights to buy that share of the land. This has been supported by a document, by an ownership bill. The ownership bill referred to the specific land cadastre parcel, where it also included a reference to the arable land. This was the content of the proposal. To that, we need to also add that the general principle of reliability of texts, of decrees, of documents needs to be respected, of title deeds issued by the cadaster is also called material declaration. The data inserted into the cadaster are inserted on the basis of the proposal for insertion. Once the court received the document that this is a parcel that includes arable land, and I don't know whether it was the obligation of the court to examine that. I don't think it was the duty of the court to examine the document. Simply, the general principle stands that such document is valid unless proven otherwise. And since no one has objected the validity of the document, I don't think it was for the court to study the Road Act. That's the fact.
So could you please be shown exhibit LF26? The Slovak version, I think it is page 29. Is this the provision that you are alluding to in your answer to my previous question?
áno, paragraf 70,
Yes, Article 70, paragraph 1 states that the cadastral data referred to in Article 7 shall be deemed to be reliable unless proven otherwise.
Could you read the final sentence of Article 70, paragraph 2, please, to yourself?
prečítal som.
Yes, I've read that.
And do you recall that in Ms. Varianova's request for an interim injunction, she was seeking an order restraining AOG from using the land plot registered in the E register as number 2721/780?
Áno, je to tak.
Yes, this is the case.
So the type of land registered as a parcel of the E register is not deemed to be binding cadastral data, is it?
Áno, zákon
Yes, the Act says that the reliable data is not stamped from the type of the registered. It doesn't, however, mean that the court is obliged to investigate the nature of the land parcel. However, the party to the proceedings is dominant litis unless it requires such an examination, unless such issue is to be examined. Then such data can be examined.
Could you now be shown exhibit MS1, please? MS-1. Have you seen a copy of this judgment of the Supreme Court from April 2021 to which Professor Stevchek refers in his expert report? Have you seen it before?
Zkuste položit dotazku.
If you could please formulate the question.
Sure. My question is whether you have read a copy of this decision of the Supreme Court before coming here to give evidence today.
Myslím, že jsem ho celé nečetl.
I don't think I've read the full extent of it.
Okay. Perhaps I can refresh your memory, to be fair. If you could go to your first expert report, please. I'm just getting the exact paragraph number. It is at paragraph number 68. It starts at 66, and to be fair.
Už si vzpomínám.
Oh, yes, I do recall now.
And I'm going to just start with some basic questions, which I hope you may be able to agree with, in which case we can take this line of questioning a bit more quickly. Do you agree that in this case, the case began in the first instance court as a private law dispute about whether the defendant was obliged to refrain from using the claimant's land plot?
V prvom rade
First of all, it has to be said that the scope of this dispute had a different dimension. It has a public interest dimension, because this was a special purpose road, public road, and the action aimed towards establishing whether on a basis of applicable law the use of road should be prohibited.
You can do this by reference to the decision then. If you could be shown, please, exhibit MS-1. And in the first paragraph, beginning with the word resolution in English, and in the fifth line in Slovak, seventh line in English, the judgment records that the dispute concerns the obligation to refrain from the use of real property. Do you see that?
vidím.
Yes, I can see that.
And in the next paragraph, beginning with the words grounds of the judgment in the English translation, you can see that the claimant sought a judgment ordering the defendant to refrain from passing through a land plot which the claimant owned. Do you see that?
Áno.
Yes, I can see that.
And the claimant argued that the defendant was passing through that land without the claimant's consent. Do you agree?
Ano.
Yes,
So as formulated by the claimant, this was a private law dispute about the use of the claimant's real property. Do you agree?
Ale to je úplne...
but this is a totally different merit because here the party to the dispute was not the owner. This was not a dispute between owners. Therefore, we cannot apply this stipulation of the law to this case. Because as long as I remember, this dispute was about prohibition of entry or the prohibition of use of a private road, which for many years was used for access, for entering. However, here the jurisdiction of civil courts has not been established to act in such a matter. So this is clearly based on other merits and also on other legal situations. So I don't think that this case law can be used in this case as well.
See in the paragraph again, beginning with the words grounds of the judgment, and then it is in the English 6 lines down. The claimant sought that entitlement on the basis of a statement that a road had been built on the land in question, of which the claimant is the owner. So the claimant was the owner of the land on which the road was located. Do you agree?
Ale ten, kto to používal,
But who was using it? That person that was using it was not the owner. So that was not a dispute between two co-owners.
The defendant's defense was it had a public right
No,
to use the road.
ale v našom spore,
But in our dispute, the one which is submitted to this tribunal, this was the case of two co-owners, one supposed co-owner and one factual co-owner. So we are focusing on a solely private property dispute. This has a different public law dimension. Therefore, it is unapplicable in this case. I have also argued along the same line in my expert report.
Okay, well, let's go on a few more paragraphs in the judgment. So if you could turn to page 3 in the English text, please, and page 2 in the Slovak. I'm afraid the paragraph numbering does not entirely correspond, and it is rather dense, so I will try my best. Do you see a paragraph in the English beginning with the letter 5, number 5, in the middle of the page, beginning the Supreme Court of the Slovak Republic, brackets, the Supreme Court or Final Court of Appeal? Does the tribunal have that part of it? And sir, do you have that section?
nevidím to.
Yeah.
I can't see it.
Yes, I'm afraid it's very difficult. If you scroll down slightly, if we could scroll down in the Slovak slightly, please. And there should be a number 5.
Somewhere between the 4 and the 6.
Yeah.
Doesn't seem to be there.
No, it's before that. I wonder if our friends on the other side could help us locate the right paragraph. It's the paragraph beginning the Supreme Court of the Slovak Republic.
Najvyšší side, however that's pronounced.
Yes, 5. There we go. You got it. Do you see that section?
Ano.
So the Supreme Court concluded that the subject matter of the case was not an issue falling within the jurisdiction of general courts, and cancelled the judgments delivered by the courts in the proceedings below, stayed the proceedings, and referred the case to the competent authority. Do you see that?
Vidím to.
Yes, I can see that. I've read that.
And so that order would only have been made if this was a dispute between two private parties which the court was granting a stay of in favor of the competent authority. Do you agree?
Já si myslím, že
I believe that there were strong items of public law interest. Therefore, the invalidity or the lack of jurisdiction has been mentioned here. I think, again, that the merits of the case were totally different. In our case, we talk about the dispute between two co-owners. In this case, however, this was a dispute between the owner who wanted to prevent his road to be used against his will. So this is a totally different situation and a different case. I don't want to assess the merits of this case, but as again, this ruling is inapplicable to the case presently being discussed.
But if the court in the case at hand, in other words, between AOG and Ms. Mariana Varianova, was required to assess whether it had jurisdiction, don't you agree that the court's decision in this case about whether a court had the jurisdiction to pronounce upon the status of a road was relevant?
rozmýšľam, ako stručne odpovedať.
Well, I'm now trying to find a way of how to respond shortly. Disputes between co-owners and ownership disputes cannot be resolved by anyone else according to Slovak legal system other than a court. In this case, as this was a dispute on co-ownership, it's always a civic dispute because this is a civil dispute, and this is specifically covered by paragraph 48 and following. So in that case, the transfer of ownership rights or preemptive rights are being discussed. Such disputes simply cannot be interrupted and forwarded to some other proceedings, especially if we base the decision on the fact that the submitted evidence testify towards a civil character of the dispute. If we had a dispute between two co-owners of a land lot where, for example, the body of the highway is built, irrespective of what is on the land lot, it is still an issue of a dispute between two co-owners and no one else would rule on that, only a civil court. Different issue is the fact that a highway body has its own road body, which has been certified, that has been legally introduced into operation according to the valid legal norms. That's a different situation. However, field road, which has no body of road, is simply to its full extent in the ownership of the co-owners, and no one else can rule other than court. That's what is the main difference here, that this is a dispute between two co-owners, and what we see here is an issue in public law and public interest. Apologies for sharing my own personal opinion, but I think that in order to resolve the ownership dispute, it's irrelevant what is built or what is present on the piece of real estate. The land can be bought as it is.
Clear.
Rozumiete.
I have no further questions.
Ďakujem.
Questions and redirect, Mr. Prakash?
Yes, please, just a few. Dr. Fogash, you remember being shown two decisions of the Slovak Supreme Court regarding the qualifications to the requirement to show the threat of imminent harm. Do you?
Myslím si, že ad hoc také.
I think that ad hoc such decisions are present.
You remember being shown them.
Myslíte tie rozhodnutia, ktoré som tu videl?
You think those that have been shown here? Yes, I've seen them, yes.
And these were exhibits MS2 and MS3. In the interest of time, I will represent to you that these decisions are dated 23 May 2012 and 29 April 2011 respectively. And now I would like to show you an exhibit to your first expert report. The exhibit number is LF10. So this is do you recall having opined on that decision in your first expert report, sir?
Nevidím ten skutkový stav.
I don't see the description of the case here. The merits of the case.
Well,
Myslím, že áno.
I think so, yes, I think I did.
and I would kindly ask you to look at the date of the decision. It's not translated into English, but if you read it out loud in Slovak, it will be.
Ja to neviem čítať, lebo to sa nehybe.
The last line of the first paragraph, sir.
12, áno.
2012, I can see it now, yeah.
Sorry. That's my mistake. Scroll down to the very end of the document. Oh, so we need the last page of the Slovak document.
Áno.
Yes.
Well, now the interpreter said something I didn't say. The interpreter actually said 26 November 2012, so that's why the witness answers yes. But you agree that the decision is dated 26 November 2012, correct?
Áno.
Yes, I do.
And now if we look at page 5, please. Does the Supreme Court opines on the standard of harm which is required for the issuance of an interim injunction in its decision?
No, súd tam hodnotí
Well, I can see that the court assesses the conditions that need to be satisfied for the issuance of immediate injunction, that the certain basic facts allowing for the conclusion about the probability, about the imminent harm need to be certified first. So this is the term that we have been using so far.
That's not what the English side says.
všetky podmienky treba
All conditions need to be certified before issuing the immediate injunction. This is what it refers to.
If I may, please help. Yes, this is a very strangely formulated sentence. It is in a negative, so even the interim injunction cannot be granted without certifying imminent harm.
Thank you.
len na základe návrhov. Pardon, môžem?
No, I think it's,
May I?
Does certify mean who certifies? The
so-
applicant states that. Is that what it means?
no, Madam President, so in in the Slovak language, there are two different levels of proof, which is
Yes.
very imprecise. One lower, which is used for interim injunctions, and higher, which is used for the decision on the merits. And in Slovak, there are two different verbs to explain these two. So we just propose to use certify because
For the lower,
for the lower
which is
standard of,
just show the likelihood.
yes.
So it's the general standard that is well known for provision of remedies. Yeah.
Yes. So,
Ano.
Dr. Fogashi will agree with me that the court here only refers to imminent harm without any further qualifications, correct?
Áno, je to tak.
Yes, this is the case.
And if you remember, we saw that this decision post-dates the two decisions that were shown to you by counsel for claimant, correct? Now, it post-dates. Sorry,
Yes,
that's
sir.
correct.
Áno, je to tak.
Yes, this is the case.
Viem. Môžem ešte vysvetliť.
May I perhaps explain one mechanism? Since I was also part to the meeting of the College of the Judges of the Supreme Court in relation to adopting measures that shall be published in the collection of the rulings and the case law of the Supreme Court. Often the situation occurred where some of the tribunals ruled and a different Senate would rule in a different way. In such case, the College of the Judges ruled that given the case that the cases were highly specific and highly different, which are rare and seldomly replicated, such rulings would not be published in the collection of case law in order to make sure that an exceptional case would become a rule. Rather, the College of Judges decided to wait for the new civil code.
What about this case? Was it published? Do you know?
Prosím?
This particular judgment we're looking at of November 2012, was it published? Is it any more authoritative than the other two?
Nie, ja si myslím, že toto je.
I think that this is one of those rulings that were not published. It only shows that the terminology was later used as a legal terminology. Perhaps could we return it back to the beginning?
Áno, je to tak.
This is the case, as I've said.
For the moment, either council have any further questions?
Neviem, či má jedna zo strany ešte nejaké ďalšie doplnenie.
Yeah, I was looking to you.
Sorry. I didn't understand your question. Any questions? No questions either from my side. So, Dr. Fogash, thank you very much for your assistance. This ends your examination.
Ďakujem aj za vyp-
Thank you also very much for having me here. Have a nice evening.
No. This is my trophy.
You can take those with you as a souvenir.
He was asking whether it's his trophy.
Yeah.
Yeah.
We should now take a break. Is that fine? And then we'll hear Mr. Atkinson.
Thank you. Yes, that would be
I
fine.
think we need to rearrange on our side a little bit. 5 minutes will be enough.
No, I think we can take 15 because we have been going for an hour, 45 minutes now. For the court reporter and the interpreters, they will be happy about a break.
See.
They We are not, yeah, they have it on the break. Yes, absolutely. No, that's right. Thank you for saying so. And that is a good opportunity for me to thank them. It was very smooth. Thank you very much.
Thank you as well.
Good afternoon, Madam President.
Sorry about that. Can you please confirm to us that you're Alan Atkinson?
That is right. I am Alan Atkinson.
Yes, that's what I understood. You're from Retro Resources.
That's correct.
You're one of the 3 experts that we will hear
Yeah.
from your firm. You have provided us with 2 reports. The first one dated 28th of September 2022, the second one 5th of September 2023.
Yes.
You have them there?
I do, thank
Yes,
you.
good. You are heard as an expert, you're to make all the statements in accordance with your sincere belief. Can you please confirm that this is what you will do?
Yeah, certainly. I solemnly declare upon my honour and conscience that my statement will be in accordance with my sincere belief.
Thank you. And now a presentation, we understand. As you know, you have 15 minutes for your presentation.
All right, thank you very much. Well, good afternoon, everyone. Is the clicker working? Clicker's not working.
Not on our screen.
No.
Not yet.
Some technical difficulties on our side here as well.
It's working before. Good. Thank you very much. Okay. Good afternoon, everyone. My name is Alan Atkinson. I'll describe the geological and geophysical work undertaken for this arbitration. My instructions are shown on the left of this slide. Oh, sorry, no, they're not. And this is a summary of my experience for your later reference. I'm afraid my clicker's a bit sticky. Okay, bear with me. There's a delay. Okay. My instructions are shown on the left here. They were to identify prospects on the claimant's license area, calculate petroleum volumes in those prospects, and calculate the geological chance of success of finding petroleum in those prospects. The work I undertook is listed on the right-hand side there, which addressed those instructions. In addition, I undertook some benchmarking exercises to check my volume estimates were reasonable and to check my geological chance of success was reasonable, supportable. And I'll go through all of the following slides. So starting with assessing prospectivity, the prospectivity of the area is indicated by nearby oil and gas fields in southern Poland, shown as red and green spots on this geology map. They lie in a similar geological basin to the claimant's license area. The claimant's license area itself contains lots of evidence for the presence of oil and gas, including oil seeping out of the ground, oil and gas shows in every well that's been drilled in the area. It also contains one old oil field, Mikava, which was providing oil to the Germans during the Second World War. I'll draw your attention just to one other well. This is one drilled in 1900, Vishny Radvan 1, which shortly after commencing drilling, oil spurted 12 meters into the air, as drawn to scale on that photograph of the Mikava field.
anyway, with all that evidence, I concluded that the area was prospective for oil and gas. So I just mentioned a moment ago that I thought there's some similarities between southern Poland and the claims license area in Slovakia. So let me, there are also some differences, and I will describe them on this next slide. Polish oil fields are found on the Silesian nappe, the Jukla nappes, and the Magura nappes, which are geological provinces. Slovakia, that's in Poland. In Slovakia, we only have the Magura nappes and the Jukla nappes, so there's immediately a difference. And a lot of the oil and gas is found in the Silesian nappe. It's found on the other nappes too, but on the Silesian nappe. So I would suggest that the Silesian nappe is analogous, but not identical to the Magura nappe, because it shares very similar geological history, depositional mechanisms, how the rocks got into the sea or the ocean that was formerly the Magura nappe. It was largely shale, occasionally sands were deposited in there, sort of underwater avalanches of sand shooting into the base, creating turbidites. It had the same tectonic history. So as Africa sort of moved north and smashed into Europe, it created mountains, the Alps, the Carpathian Mountains, and these same forces created the structures that are formed by prospect. So it has many similarities. There are differences. A key difference is that in the Silesian nappe, there are better sands. We've got plenty, there's lots of wells, there's proven to be better reservoir sands. So they're thicker, maybe up to 50 meters thick. They're good porosity, they're 11%. That's just an indicator of how good they are. In the Magura nappe, by comparison, they're 7.5%. Lower number, less good sands. So, some basic rock differences there, but enough similarities for me to be able to use it as an analogy. Another difference is there are many more wells drilled on the Silesian nappe, and so because of that, it's yielded more oil and is better understood, as I'm showing you here. So on the right-hand side, I've displayed an elevation map, just showing you the height of the hills in yellow there. All the pink spots there are the wells drilled in Poland, and as you can see, they number in the thousands. In contrast to the white spots, which you may or may not be able to see in Slovakia, you may not be able to see them because they number in the tens. There's not very many. It's very clear from this map that the claimant's license area clearly needs more drilling before it can be said to be fully appraised. Why are there fewer wells in Slovakia? Well, it's a different country. It's part of the Austro-Hungarian Empire until the end of the First World War. In southern Poland and in Slovakia, you can see from the elevation map that it's hillier. Those hills are covered in trees, and back in the 19th century, early 20th century, access would have been more difficult as it is now. It's just meaning there's just generally less oil and gas activity. Another thing to note is even to the untrained eye, if you look at the shapes on the left-hand map, which is the geology, on the right-hand map you can see the hills, and the hills and the geology line up to one another. So back in the 19th century to early 20th century, it was fairly easy to link an oil seep with a hill. I'll dig a pit there, I'll drill a well, find some oil, and you can do your exploring on a surface map, on a structure map. In the southern Poland and Slovakia, it's that much more difficult. It's hillier. It's a little less clear, the linkage between the underground geology and the surface, and you need more technique like seismic to help you find the oil and gas. So there's some differences. So moving on to defining prospects then, having established the prospectivity of the area. So based on all the evidence, I would expect to find petroleum in folds. And this was, as I mentioned, created by Africa colliding with Europe, rumpling the surface rocks like you're pushing a tablecloth and it all gets folded over. That's the sort of fold that I'm looking for in the scaled up in the geological record. So I'll show a seismic section, which is what that is a vertical slice through the earth. Just imagine slicing down a few kilometers into the earth. And different rock strata are indicated by different colors there. And what you do is you interpret horizons, these boundaries between the different rock strata. And to the trained eye, you can see some folds up there. Now, I'm not going to expect you to spot them. Even to an expert, they are rather difficult to see on this seismic. The seismic itself doesn't reveal the detail of the folds, but they are, so I've indicated where the folds are on that seismic section. And by showing you these examples from Poland, you can see what sort of traps, prospects I'm going to expect. I'm expecting folds. Basically, the trap that the oil is going to accumulate in is like an upturned bowl. And if in that upturned bowl you've got some reservoir sands, but you've got poor space between the grains of sand, oil will percolate up and collect in the reservoirs in that trap. The sands, the oil doesn't escape because there's the green layer, there's the shales overlying the sands, and that's what stops it from escaping. So that's the basic prospect that I'm looking for in this area. There you go. Moving on to, so with that in mind, I'm going to show you how we calculate the volumes. So I've got a map on the right-hand side. Now that map was made by from the interpreted horizons. And on the left-hand side, you can see another seismic section I've highlighted in that green horizon there. If you interpret that on several seismic sections, you can end up making a map like on the right-hand side. I identified prospects as separate bumps or closures on that map. So where I've got close to where I've got the arrows on the right-hand side. Now, often in the North Sea, the Gulf of Mexico, modern places, you'll have 3D seismic data. Now, you have seismic lines every 25 meters, regular over the whole area. If you've only got 2D seismic, quite often the seismic is acquired maybe every 250 or 500 meters, and you make maps from this data. Our seismic sections here are separated by 3,000 meters or 6,000 meters, depending on where you are. So what we've got is not very much seismic. It's not a seismic-led exploration area. And the surfaces are rather poorly constrained between the lines. Even on the lines, as you can see on the left-hand side, this is a section taken from Dr. Long's report, and that white arrow indicating uncertainty and where the green horizon goes, that's his arrow. And I quite agree with him, it's somewhat uncertain where the horizons go. So the horizons could be shallower or deeper. And what that means, if I just draw on there that blue horizontal line, that's maybe suggest that's an all contact, then you can see that the uncertainty in the horizon, the green line, leads to uncertainty in what the area, the extent of the prospect is, and that leads to uncertainty in the volume too. It might be a little tiny volume, it might be a middle-sized volume, it might be a big volume, and you can see that this considerable structural uncertainty can lead to significant volume uncertainty, and you could have half the volume, you could have double the volume. It depends on how the true nature underground strata are. So Dr. Long took the prospects that I've mapped, and he said that, well, the areas of my prospects are the largest they can be, pretty much as large as they can be. And when he went through the complicated process of calculating volumes, he said, well, I'm going to make that the P10. In other words, in all the different combinations of area and thickness and all the complicated volume calculation, the area will only be bigger than Alan Atkinson has mapped 10% of the time. Most of the time, the area will be smaller than that. When I ran the volumes, I said, well, my mapped areas, there's uncertainty. And so I think half the time, the area of the prospects could be larger, half the time it could be smaller. So I put it as what they call the P50 in the volume calculation. And I did that because I thought that was a fair representation of the uncertainty in the surfaces that we'd in the prospects that are created. So this is a critical difference because with Dr. Longman's approach, it causes the hydrocarbon volumes, the petroleum volumes, to be 40% lower than the ones that I've calculated. And it's down to whether you say the areas or the P10 or the P50. So of course I stand by my own numbers. I think Dr. Longman is wrong to pin them at the P10 because basically he's saying that the prospect area essentially can't be very much larger than I've mapped. And I think that underestimates the uncertainty in the structures. So there we are. That's volumes. Now, with all that uncertainty, even I, when I run through the process and try to apply best practice to generate these volumes, I need to check that I've not gone very far wrong. So I did some sense checking. I undertook a benchmarking exercise. I contrasted the volumes to the next door oil and gas basin in Poland. This is a figure from one of my earlier reports. I won't go through it in detail, but it shows that the volumes I calculated were conservative compared to Poland. 13 million barrels compared with 51 or 63, however you want to compare it. So Dr. Longman undertook his own benchmarking exercise, and his results led him to the opposite conclusion, that shown by the orange bar on the right of that graph there, that my volumes were much bigger than you'd expect in Poland. So the process that he did was to, if you look at the right-hand map, which was taken from his report, you see there's the pink hashed area in the middle, and that's the Silesian map. So he's got a database which tells him how many millions of barrels of oil are in that area, divided those millions of barrels of oil by the area of the pink polygon, and came up with resource density, which is plotted on the graph as the green bars there. But I suggest that Dr. Longman's taken the wrong areas here. If actually he used the correct areas, he'd come up with some different results. So as you can see, the green spots are the oil fields, and the green spots only occupy the bottom right-hand third of that pink area. So if you take the number of millions of barrels in there and divide it by a third of the volume, it gives you 3 times the resource density. So really, the resource density isn't that green bar; it's that star on the left and the middle there. Similarly, the Magura Napa oil occupies a fifth of that Magura, the polygon area, and actually the resource density is 5 times what it says there. And if you take all of the oil in all of the naps, it ends up looking a bit like that. So it's 4 times bigger. So now, by comparison, my orange bar, which is essentially the same calculation on my estimated volumes in Layman's license area, starting to look a little bit more reasonable compared with Poland, because I already think that you'd find less oil than Poland because of the difference in the reservoir quality. There you go. So that's the sense check on the volumes. My final task was to calculate the geological chance of success, and Dr. Longman and I both took essentially the same approach, and I've compared the results here. Now, for the 5 prospects that Dr. Longman did the evaluation for, you can see that his estimate on the right-hand side there of the geological chance of success, it was like 7.5%, 0.075, and I came up with something 19%, 0.19. So his estimate is 61% less than mine. And now I haven't got time, I don't think, to go through the elements of the chance of success. So I'll just focus on the biggest contributor, which is seal, which accounts for 2/3 of that difference. So I understand from a detailed review of Appendix C of Dr. Longman's second report that he's not really recognized the prospect style of folded strata that I discussed earlier on. And I think he believes the traps rely on fault seal, and so gives them a low chance of success. And by that, if you look at the right-hand seismic section there, I've got a green arrow wiggling up with leak. So there's not a folded upturned basin shape there, is there? It keeps going up, and the idea is the oil just sneaks out that black line, which is a fault, and gets to surface, so it's leaked. So the chance that black line seals is what he's risked, he's given. Now, in fact, as I discussed earlier, the folds, the traps are actually folds. They're just the seismic doesn't really show them. It hasn't got that degree, that quality. Now we've got plenty of wells which tell us that that there is seal sitting on top of the sands. It's got sand, shale, sand, shale, sand, shale, and they're in this upturned bowl shape. So really, you're relying on the shale presence for your seal, not on the fault sealing. So you come up with a different number. I've come up with 0.85 rather than 0.5. I'll just, before I move on from this slide, if I just point out these 2 red blobs there. Again, I'm sorry about this. Unless you're a trained geologist, all of this is a lot of information in a very short space of time. But those aren't upturned bowls. They are what Dr. Long was saying. That's a fault sealed trap. That you go, the sands go up, you come across a fault. If that fault doesn't seal, whoosh, off your oil goes. But you can see from there that in those Polish fields, the oil is trapped. So that fault is sealing. And that I've seen that in many examples of the Polish data, that a lot of the faults do seal. So even if they are faulted, these traps are likely to seal. There's a lot of shale in the system. Okay, try not to take my word for it. It's another thing. Calculating geological chance of success is a notoriously difficult thing to do and prone to bias and subjectivity. We understand that. All the geoscientists work with data, and we do what we can to make the process systematic and objective. I made an attempt in my first report on there, but let me just show you on the right-hand side here. There are.
I think you're
Am I over?
over the time
Okay.
unless
This-
the
the-
secretary corrects me by 2 minutes. But you can, of course,
That's fine. That
give
was
a
the last
conclusion.
slide, really. It was just showing that the published tables show that they back up my 0.85 number for upturned bull type prospects. And there you go, my conclusions. Thank you.
Would you like to take the floor?
Excellent. Thank you so much. Hello, Mr. Atkinson.
Afternoon.
My name is Douglas Palawa, and I'll be conducting your cross-examination today. You started the presentation with your instructions, and I'm going to start there as well. So if you can open up to paragraph 6 of your first expert report, should have a copy of it there.
I do.
Good.
Yep.
Great. So in paragraph 6, you state that you were instructed to provide an independent assessment of the hydrocarbon exploration prospectivity of the license areas, including an independent estimate of the hydrocarbon volumes in place attributable to the license areas and estimating the chance of finding them. Now, you understood that instruction to give you a certain level of autonomy in your assessment, right?
I did, yep.
Yeah, you weren't confined to what Discovery Global might have planned to do or what it was doing in Slovakia, right?
That's correct.
Right. So just as an example, Discovery Global had 3 authorizations for expenditures for the first 3 wells. You know that, right?
Yep.
Right. So it was going to drill at those 3 wells, but your assessment goes beyond that. Fair?
Yep.
Right. So those first 3 wells, and I'm happy to take you to the specific paragraphs in your expert report, but I'm starting at 109 of your first expert report. That first well was Smilno.
Yeah.
And I see that in your modeling, you assign that prospect number BM01.
Yeah.
Yep. And the second well was the Stromy prospect at Kriva Olka, and that's equivalent to LU07D, right?
Yep.
And third well was Ruska Peruba, and I understand that you don't think there's an accumulation of oil or gas there.
That's correct. I think that all of these prospects have a certain risk, and I think Peruba the risk was so low that I chose not to describe as a prospect.
Right, so you don't give it a number.
Yeah.
Had Discovery drilled, in your opinion, had Discovery drilled, had it moved forward, had it drilled a well there, it wouldn't have found an accumulation of oil or gas.
There'd be a low chance that that would happen. Yeah.
Right, so it's not included in your model. So I think it's safe to say you don't believe that it would have found oil or gas there, right?
I think it'd be accurate to say that I think there'd be a very low chance that it would find oil and gas, not 0.
Yeah, low enough for you to exclude it from your model,
That's
right?
correct. Yeah.
Yeah, thanks. Now, I can take you to this document, and I'm sure you've seen a few of them, but you're generally aware that Discovery Global was presenting its own version of prospects to investors and to its JV partners. You're aware of that, right?
Yep. I saw documents to that effect, yes.
Okay, I'll pull one up for you just to help you. If we can pull up C-180. Right, so this is, and we'll stay on this real quick. This is an October 2017 investor presentation. And if we can go to page 29. Right, thank you. You can see that, right?
Yep.
Okay. So, for example, here we have Discovery telling investors that it was targeting these 7 prospects. And as part of your independent assessment, you were not asked to perform any validation of these figures, right?
That's correct.
Right. You weren't asked to assess whether these prospects in particular would have succeeded. Fair?
That's correct.
Great. And I also understand that as part of this, with the data that Discovery had, you were able to select the data that you felt was most appropriate for your analysis. Fair?
I'm not sure if that's accurate. Actually, I used all the data that I was given.
Well, I'm not sure about that. So let's go to paragraph 207 of your first expert report. For paragraph 207.
63.
Thank you.
You're welcome.
63. So paragraph 207 starts with a discussion about MT data, or an MT technique that Discovery Global was using. Does that sound familiar to you?
Yeah, absolutely, yes.
Right. So if we go down to paragraph 208, you state that you were unable to obtain a detailed description of the theory of application of the MT method used on the claimant's license areas. And your ultimate conclusion is then, if we go to the next page in 211, paragraph 211. Right, so here you say, since there is a lack of peer-reviewed evidence for this implementation of the MT technique, and I was not able to establish a strong empirical basis for its predictions of pay, I would not rely on it in my assessment of prospectivity and did not use MT data to help estimate PIIP or prospect GCOS. You recall that now, right?
Absolutely, yes.
Right. Now you understand that Mr. Lewis of Discovery Global was a big fan of using this technique. Fair enough?
He uses it a lot and has trust in it, yes.
Yeah, so he's a fan of it, right?
Your words? Yep.
Okay.
The technique being MT
MT, yeah,
for the record.
for the record.
In single point MT. MT is used across throughout academia and by all sorts of people, but this particular application of multi-magnetotellurics is
Yeah, this particular technique.
not as widely employed.
Yeah, it's not as widely employed, yeah. So you have no reason to doubt that Discovery Global would have continued to use this had it continued its prospecting activities, right?
I think that's likely.
Yeah. One of the advantages, for example, of the MT data is that it's relatively cheap to acquire, right?
Compared with seismic, yeah.
I'm sorry?
Compared with seismic data. for
Yeah,
example,
compared to seismic
and
data.
Compared with drilling wells, yeah.
And compared with drilling wells. And so I come back to the original question, even though that this was Discovery's, one of its methods of prospecting for oil and gas, you excluded it from your analysis.
Yes, that is correct. I evaluated it, so I didn't ignore it, but I evaluated and didn't use it in my analysis, so you're quite right.
Yeah. And one of the reasons why you didn't feel comfortable using it is because of the lack of peer-reviewed evidence on it, right?
That's right. There's all sorts of interesting new lines of research in our business. There's a lot of money to be made, so people try new things all the time. Sometimes they catch on, they become mainstream. Other times they don't catch on and they just fall by the wayside. I think
Yeah.
this is probably in the middle at the moment, this one.
I'm just quoting paragraph 211 of your first expert report. That's it.
Yeah.
Okay. So I think we've already discussed the fact that it's not really a mainstream tool. Right?
Yep.
Okay. Now, from the date of its purchase of AOG in 2014 until it left Slovakia, the Discovery did not acquire any new data on the license areas apart from this MT data, correct?
I believe you're right. I think they reprocessed seismic data, but didn't acquire any new seismic data. I think, yep.
Yeah. So there was magnetic data, for example, gravity data that Discovery had inherited and seismic data. But from the date of its purchase until the end of Slovakia, it had only reinterpreted that data. You agree with me there?
No, and they'd done some reprocessing as well. I think
Yeah.
the seismic reprocessed, the gravity was reprocessed, the magnetics reprocessed. So they didn't, yep. So that level of work.
Yeah, so there was some reprocessing, some reinterpreting, but in terms of brand new data, from 2014 until the end of its time in Slovakia, it did not acquire any new data on the license areas, right?
Apart from the MT data.
Apart from the MT data.
Yeah.
Okay. So there was a little bit of a discussion in your presentation, and I thank you for that, about seismic data and how it's used. That's actually what you are using to interpret and map new prospects or leads. I know there's a debate between the experts on that, but I'll use prospects for you.
I was part of the information use. It's an important part, but I also used surface geology. In fact, as I said in my first report, this is a notoriously difficult bit of work place to work onshore in a thrust environment. You look at the seismic data, very experienced people like myself, they can still find it challenging to understand what the seismic is telling them. And a good way forward is to actually do what Discovery Geo did, which is to ask someone like EGI to undertake a structural restoration, because they can incorporate the seismic with other data like gravity and magnetics, and they can form an integrated understanding. So they did that piece of work, and I, like Dr. Long, took a look at that. Look, we can't better that. That's as good a piece of work as you're going to get with it, and it makes the most sense in the seismic data.
If I can, Mr. Atkinson, I was again just reading from your expert report at paragraph 72.
I'm just
trying to confirm where you say, I have used this seismic data to audit existing structural interpretations and to map new prospects.
Oh yeah, to audit, yeah. So
Right.
So I had to audit what EGI did. They did a nice piece of work, but I wasn't going to take that on trust. So I looked at the seismic data, looked at the gravity data to check what they've done.
Yeah, and so just from this paragraph again, you're using that seismic data to map new prospects, correct?
Yes.
Thank you. So obviously the quality of that data is important, right?
Yes.
And generally speaking, the 2D seismic data that Discovery was interpreting at the time to map new prospects was of poor quality, right?
Always got to be careful in making that judgment. Is the data poor quality, or is the geology make it mean that you can't see very much on the seismic? And I think it's probably a combination of the two things. So the geology is, and the structures are very complicated. That reduces the quality of the seismic. And then as a separate question, was the data acquired in the right way and processed in the right way? It's not an area which lends itself to good seismic, I think.
Right, so why don't we just pull up C46? For your help, Mr. Atkinson, you cite this document at 44 of your first expert report, footnote 44. And if we can just go to page 10, please. You know what, we can stay here on this front page just to orient Mr. Atkinson. Apologies for that. Right, so this is the qualitative and quantitative interpretation of full tensor, the gravity data that Aurelian had procured and which Discovery had interpreted. You're familiar with this, correct?
Yeah, I read that report.
Yeah, so if we can go to page 10 of the PDF itself, yeah, right there. And I think this is actually the geophysical problem that you were just talking to me about at section 1.2. If we could zoom in on that to help Mr. Atkinson see.
I think that's, yes,
Yeah.
what I just said, yeah.
Yeah, so the seismic data has generally been of poor quality in the area. And a reason for the poor quality of that is indeed, as you noted, the structurally complex geology, the intense thrusting, et cetera. Now, I think it's uncontroversial right here, and you would agree that those problems can lead to difficulties in interpreting that seismic data, right?
I would definitely agree with that.
Right, thank you. And I just want to come back real quickly to the way that you identified prospects. Say that for you. So if we could go,
Thank you.
if we could go to page 45 of your second expert report.
Okay, on that.
I'm not. Oh, there we go. Right, so just above this image is paragraph 112.5. And you explain that when you were first instructed, the claimant provided a map of 38 leads and prospects. And can you tell me why you didn't include this in your first expert report?
I included it in the second report because there was, that's right, there was reference made to the number of prospects I created.
Well, maybe this will help you.
Yeah, yeah.
And also in that paragraph 112.5, you state this, referring to when you were first instructed, this map informed my understanding of the claimant's views on prospectivity and informed my own independent view. What did you mean by that?
Good question. What I meant by that was that if you look at the site, they were going for a structural place, for starters, and not stratigraphics, which is a different thing. So we're looking for folds. You can look at the seismic, and wherever there's a blob on this map, figure 5.2, you can see on the seismic that there's potentially there's a thrust or a good likelihood of a thrust. You can link them back to the surface geology, and they are areas where, if you just take a first look at the seismic, you think there's potentially a trap there. When I did the same process using EGI's report, which is a more advanced piece of work, not surprisingly, many of the prospects sort of broadly coincided because they're based on seismic.
Right, so did you generate your prospects before or after you received this map?
After.
After, okay. And was the goal to plot roughly the same amount as this map?
No. In fact, I've got to say I generated a lot more than 40, but they were outside this license area, and so we had to cut them back. So I have many more than this.
Well, yeah, if they were outside the license area, you wouldn't put them in, right?
They were inside the an earlier version of the license area.
Understood. Thank you for clarifying that. So when you wrote your first report, did you have access to or did you know about the competent persons report that Discovery had inherited from Aurelian that covered the Slovakian licenses?
I saw that at one point. I think I can't remember the exact timing. I suspect it was after I did my first report.
Right. And you didn't mention, well, let me ask you this, in fairness. Did you see it before you wrote your second expert report?
Yeah, I might need someone to confirm this, but I think that came up in document discovery.
Good memory.
Yeah.
Indeed.
Yeah.
So
that was that. I think that was before my second report.
That was.
Yeah, just to get the timelines right.
Can you say with confidence that you reviewed it?
Yes. Yeah. I briefly at that time, and then more carefully when Dr. Longman presented it as an exhibit.
And is there a reason you didn't mention it in the second expert report?
I can say that it broadly supported what I've done when I've looked at it after Longman's report. But again, I was doing a piece of work. I really didn't care what anyone else thought. I was giving my opinion. So
Okay, well,
I think that's probably
no, that's fine. I understand that you didn't, I'm just gonna wait for the transcript because I don't want to put words in your mouth. But you said, I was doing an independent piece of work. I really didn't care what anyone else thought. I was giving my own opinion. That's right from the transcript. So can you open the your second report to page 45?
Yep.
And if you can go to footnote 107, please. I'm just a little intrigued because here you're using apparently a competent person's report that's on the Slovakian licenses from 2009 to corroborate your results. And now you just told me that you didn't use the Aurelian CPR because you were doing an independent piece of work. And I'm just trying to understand how you chose to use which one.
Oh, well, I didn't really use that, did I? I commented on it in a footnote.
Well, I don't know. I think you state in here in 107, you say this is in line with my estimate. And I read that to be, you were using that to support your estimates. Is that a fair reading?
Let me describe that. I think is CPR produced by Gaffney Klein? Which CPR is that? It's not obviously not the RPS CPR.
No, I was asking myself the same question because the
Yeah,
CPR
no,
is actually,
it's a different one.
it's not actually in the record. It's
Yeah.
simply referred to in that document, which raised some questions for me.
Okay, yeah, I think that CPR was shown to me and late in this is the second report on that. I think late in the day I probably saw that and because it was new information, I thought make note of it as it was information I'd seen.
Yeah, so
I
it was new information to you, so you included it in the second report. The Aurelian CPR was new information to you, but you didn't include that in the second report.
Yeah,
That's fair?
Yeah.
Yeah. And what about the draft 51101 that Discovery Global had acquired as part of its investors fundraising efforts? Were you aware of that document?
Again, I think that one came up during document discovery. So
Right.
That was had a look at it then, and then had a closer look when it was presented in double second report.
And is it fair for me to assume that you didn't include that document either because you were conducting an independent assessment?
Struggle to remember quite what I thought when I first saw it, but I certainly, after the thorough review, it was a very poor piece of work and really didn't contribute to my understanding of the prospectivity of the area.
Right. So the CPR from 2009 that you reviewed but didn't attach to your report was a better piece of work, and that's why you relied on it?
The footnote 107,
Yeah.
the single reference to the CPR in my report. We're
Yeah.
talking about here the Gaffney Klein.
Yeah, the one that you used to
2009.
support your estimates, that one.
All right. I think I'd call that footnote 107 an off the cuff comment that someone else had produced volumes which were similar to mine. What I could have done is also mention the RPS CPR, which supported my chance of success estimates and volumes are quite similar. And if I had mentioned the 51, I'd have said that it was a poor piece of work and wasn't worthy of comparing with.
Right. So you could have done all that,
I
but
could have done
you
all
didn't do that, right?
No.
Maybe we should take a look real quickly at the SLR report just to maybe get your thoughts on something. So if we could pull up Dr. Longman's second report, it might also be referred to as the SLR report, the second one. And if you can go to paragraphs 24 and 25. Right, if you can zoom in on those. So I think you had said earlier that you had reviewed the RPS CPR before your second report. You believe that it supported your estimates, but you did not attach to your second expert report. Is that fair?
Just to be absolutely precise, I remember looking at it. We had a discussion about it, about its significance, and moved on, and took a closer look at it in response to Dr. Long's second report. So I think we just didn't attribute too much significance to it.
Right. Is the reason why you didn't attribute too much is because the geological chance of success in it is 2 times yours?
2 times smaller?
No. I'm sorry, 2 times smaller, yeah.
Okay,
The
yeah.
difference is 2 times.
Yeah. I'm sorry, but you just Dr. Longman's actually not taking the correct information from the RPS CPR.
Oh.
If you look at the next page there's the true chance of success for Zaboro A and Zaboro B.
Yeah.
And instead of being 6 or 8%, it's actually 16%. I don't know if anyone can confirm that,
Right.
or 32%. He's just not read the CPR properly and misunderstood the chance of success. So when you drill a well and it's got 3 reservoirs, in it,
I understand,
you have 3
Mr.
bites of
Atkinson.
the cherry, so the chance of success is
Mr.
greater
Atkinson,
for
please.
1 reservoir. So
Mr. Atkinson,
that's actually wrong.
you'll get the opportunity on redirect.
Okay. No
Yeah,
problem.
thanks. So you could have said all of that in your second report, right? Because you had reviewed this document. And I'm just trying to understand why you included some and didn't include others. So your testimony right now is that you reviewed this, you made some conclusions about it, and you excluded it. That's fair, right? Yes or no?
I think my statement is that we've fairly superficially reviewed it, gave it a read through, discussed the contents and moved on, which is a different level of review to that which I gave it when Dr. Longman included it as an exhibit in a second report.
Did you take the same level of review for the 2009 CPR that you included in footnote 107?
Yeah, superficial, I guess. Yeah.
Superficial, but good enough to include in the report
As a footnote to my report.
to support your estimates, right?
Yep.
Okay. Okay, moving on to PIIP. And just a brief.
It's always dangerous to try to imagine what's in council's mind. I know that since that's where I spend much of my life, but I wonder whether in due course, the suggestion is going to be made to the tribunal that you included reference only to studies or estimates or reports that you decided were in line with your estimates and excluded those which weren't. I don't know if that's what we're going to be told, but just in case it is, what would be your answer to that?
No, is my answer. Everything I looked at thoroughly contributed to my report and has been mentioned. I've been very open about what's so nothing's been excluded. The only things that haven't been heavily incorporated were things that I looked at briefly, and there were things that weren't at my disposal when I was doing the majority of the work. But for example, in document discovery, we had a quick look at some reports, and I can barely remember this Gaffney Klein report. It was just brought to my attention. We had a look at it and thought, well, that's not going against what I've said, so include a reference to it.
Very good.
Yeah.
Thank you.
Yeah. And the same with the RPS report. I should have included that because that was actually quite supportive.
Thanks.
No problem.
Please continue.
Thanks. Just talking broad strokes about what PIIP estimates are. Well, your instructions are to calculate an independent estimate of hydrocarbons hydrocarbon volumes in place and then estimating the chance of finding them. There is a level of uncertainty in this. You acknowledge that, right?
Very, very much so. Yeah. In fact, our job is to capture the range of uncertainty.
Right. So there's a level of uncertainty in this. Now, without drilling an actual exploration well, you don't actually know if there's oil or gas at that specific accumulation. Fair?
That's correct. Yeah.
Right. And the estimates, of course, are only as good as the data you have on hand. Fair statement?
Yeah.
Good. So you talked about this a little bit in the presentation you just gave, but Discovery's license areas lie within the Magura and the Dukla naps, right?
That's correct.
And all of the prospects that you've created in your reports are within the Magura and the Dukla naps, right?
That's correct.
Yeah. So when it comes to your petroleum initially in place calculations, those amounts represent the estimated volume of hydrocarbons that are potentially available within each prospect.
Yeah.
Yeah.
Yep.
And obviously these are still only potential amounts, but with all of your prospects being within the Magura and the Dukla naps, the PIIP estimates represent potential amounts of oil and gas within those areas of the Magura and Dukla naps.
Correct.
Now, I think you said it earlier, but if you could just confirm historically, the Silesian nap has been more productive than the Magura and the Dukla naps.
That is correct.
Okay. Now I want to walk through briefly the three benchmarking exercises that you undertook. So we're going to start with the first report. I know you've updated it, but we'll get to the second report. I'm just saying that now in case you feel compelled to take me there. So if we could start with the first benchmarking exercise, and we'll go to paragraph 175 of your first expert report on page 74.
Oh, sorry, say that again. The first report.
First report.
175.
Thank you, Mr. Farmer.
Paragraph 175?
Correct.
Oh, sorry, yeah, misheard you.
No, you're fine.
Yep.
Okay, so this is your benchmarking exercise to show that your PIP estimates are reasonable. And you benchmark your results against 3 anticlines in the Silesian nap in Poland, right?
That's correct.
And we can see those in the image there after paragraph 178. The average of those 3 anticlines in the Silesian nap is 49 mmBOE, and the average of each fold that you analyzed in Discovery's license areas are 11 to 14 mmBOE per fold. You recall that?
Yes, I do.
Okay. And I understand that because that analysis showed that the claimant's license area contained lower amounts than the benchmarked amounts, you concluded that this was reasonable. Is that fair?
That's fair.
Okay. But you do agree with me that it's expected that the Silesian nap contains more oil or gas than the Magura and Dukla nap, right?
No. No, I don't agree. I don't think that it's proven to have more oil and gas because it's been drilled. I think on the basis of the wells that have been drilled in the Magura nap to date, it's fair to expect the Silesian nap to have more. It's not to say that in the future we won't find that more wells drilled in the Magura nap and we'll find better sands. I think the basic point that Silesian nap's probably generally got more oil than Magura nap is a fair point.
Okay. I realize there's a lot of uncertainty in the oil and gas world and figuring out what will happen in the future, but I think I heard you say that generally we would expect the Silesian nap to have more oil and gas than the Magura and Dukla naps.
Yes.
Okay.
Based on current data.
But comparing the PIIP estimates to the Silesian nap says nothing about whether the estimates are reasonable in relation specifically to the Magura and the Dukla naps, does it?
I think what I was attempting to do with this was just to say, if my volumes had come in higher or the same as the Silesian nap, I would have been worried. And well, in fact, I wouldn't be worried. I would have redone my analysis and changed some assumptions to get to a lower number.
If I can ask you about that right there. Sorry, but if it would have been higher, that would have caused concern because historically, the Magura and the Dukeland apps have produced less oil. Right?
Yes.
Okay. So you're going over to 3 anticlines in what has historically been a more productive nap. But that says nothing about what's taking place within the Magura and Dukeland apps in relation to themselves. Do you agree to that?
I'm not sure I do. Where the Magura nap's been drilled so far and is in Poland, there's various smallish oil fields been found. There's nothing, if you come 50 kilometers south to the claims license area, you may find the same small oil fields, you may find bigger, you may find small.
Yeah.
Yeah.
Yeah, that's fair. But you were very specific to choose 3 anticlines in the Silesian app, and nothing prevented you from doing that exclusively within the Magura app, correct?
I can explain why I chose those ones.
No, I just want to, you had the ability to undertake a benchmarking exercise exclusively within the Magura app. You had that ability, right?
No.
I think you just did it on your slide earlier today.
It's because the folds are less easy to identify because they're a little more complicated than the Magura app. So the Silesian app, you can see the folds are on the map that you're seeing that there now. The surface geology map allows you to identify where the folds are, so they're just easily identifiable. So
Okay.
I went for the easy folds that were the easiest to be able to be identified.
But there is oil production in the Magura app, right?
There is.
Okay. And we'll come back to the 3rd benchmarking exercise that you've done, but that was done exclusively, part of that exclusively within the Magura app, right? In fairness, Mr. Atkinson, we'll bring it up and come to that.
Yeah.
Okay, so let's go to the 2nd benchmarking exercise that you did in your 2nd report. And if we can keep this image from the 1st report. Oh, sorry, should have told you before. Okay. Are we able to go back to the original page that we were just looking at? Sure. I believe this was page 74 of the 1st report.
Actually, page 53.
Oh, is it page
seems to
53?
me.
Yeah, that one right there. Keep that one up. And then in the 2nd report,
Page 13.
I think it's page 33 of the 2nd report. Right there. So this 2nd benchmarking exercise, and if we can zoom in on the top one, I'm just interested in the area that's selected.
One on the right-hand top.
That would be great. Thank you very much. I think the one above that, sorry. Yeah, thank you. So you've selected 2 100 or 1,245 square kilometer areas. It's the same size as Discovery License area. But if we look at these pictures, this new benchmarking exercise still captures almost the entirety of the 2 larger anticlines from the 1st benchmarking exercise, right?
Yeah.
And if we look at both images closely, if you can kind of zoom out on that one a little bit, this 2nd benchmarking exercise only extends into the Magura app just the slightest bit. I noticed the borders are removed on the right, but if you're looking at the images, it just touches the Magura app the slightest bit. Is that a fair characterization?
You're talking about the
Right.
Well, it captures a lot of the oil fields on the Magura Nap, I believe.
Right, it captures that tiny little pocket.
Yes, where the oil is on the Magura Nap.
Yeah, where the oil is. That little sweet spot. Okay, so what I'm struggling with is, why didn't you just draw this area exclusively within the Magura Nap?
Because at this stage, I think I have oil and gas fields in the Magura Nap and the Dukla Nap in the claimant's license area. So not exclusively in the Magura Nap. And I was just estimating average properties across those two naps. And I was just choosing areas from Poland in the blue polygon, which incorporated two of the naps as well. I wasn't, it's not just the Magura Nap in Slovakia, I think is what I'm saying.
I understand that, but if you want to look at what's in the Magura Nap, isn't the best place to start the Magura Nap?
Looking just at the Magura Nap. I was looking at the Magura and Dukla
And the
naps.
Dukla Nap. So wouldn't you look in, if you want to look at what's expected from the Magura Nap, you look at the Magura Nap. If you want to look at what's expected in the Dukla Nap, you look at the Dukla Nap.
I see that the basins are analogous, and that I can use the Silesian Nap to compare with the Magura Nap, with the caveat that there is less good reservoir there, and that and so any estimates I make from my, remember this is a benchmarking exercise, so I'm contrasting. I'm not trying to find the resource density in the Magura Nap using the Silesian Nap data. I'm saying how much oil per square kilometer is there in Poland. I'd expect to be below that. I'm contrasting, I'm benchmarking. I'm not saying they're the same.
I understand that, but I don't understand benchmarking to be the same or necessarily what the purpose of this is. The ultimate purpose of your expert report is to give an amount that is found within the Magura Nap. You are giving the tribunal an amount that's either in the Magura Nap or the Dukla Naps. Those are where all your prospects are, right?
Exactly.
Those are where all the prospects are, right?
Yep.
Exactly. So the purpose of the PIIP estimates are to tell the tribunal that we should expect a certain amount of oil and gas from the Magura Nap and the Dukla Naps. And my question to you is, why go looking for an analogous basin when you can just look in the Magura and Dukla Naps themselves?
The reason is because in the Dukla Nap, and let's start with the Dukla Nap, it contains certain reservoir sands, I call them menolite type sands, the better quality sands, and they are found in the Dukla Nap in Poland, and they're also found in the Silesian Nap. So I can use all of the Silesian, in my estimation, I could use all of the Silesian data to support prospects directly in the Dukla Nap. So that's one reason. The Silesian Nap has oil fields in the better quality reservoirs. It also has oil fields in the poorer quality reservoirs. So mixed in amongst all those oil fields in Poland are some although they're in the Silesian Nap, they contain similar rocks that you'd find in the Magura. That's what I mean by analogous.
I'm not sure I understand this, because I understood before that the Silesian Nap would be more productive as a rule. So if you just make it analogous, that doesn't take into account the higher productivity.
If I may just say what I mean by analogous, the analogous is not I would make a point of saying it's not the same as, but there's so many.
That I understand.
Yeah, there's so many similarities that geologically they're analogous. Specifically, I'll find some of the really best reservoirs in the Silesian Nap, and I won't find them in the Magura Nap. So the very best reservoirs, but the poorer reservoirs, the Flysch, the there's the stuff where there's just
Yeah.
shale and then the sand, shale and the sand. They're not so good reservoirs. That's everywhere. That's in Silesian Nap, Magura Nap, Stukla Nap. So some of the oil fields in Poland have sands which are, even though they're more similar to the Magura Nap. The opposite is not true. Magura Nap does not have sands similar to the best ones in the Silesian Nap.
That may be the issue, no?
So when I started this whole exercise, I thought I can keep things simple. I can work out the resource density in Poland or somewhere, the millions of barrels per square kilometer, and just multiply by 1,245 square kilometers. And I immediately hit the problem that I indicated that Dr. Lohman had run into. What is the resource density? What is the area that I should consider? What is how many barrels do I put in that equation? It's a very difficult thing. So I went down the traditional route of mapping specific project prospects, and I thought that would be more defendable, more transparent to everyone. So I took that approach, and so I did that. I came up with a number, the amount of oil in place, but as you've seen, it really is uncertain. So I've got to make sure that I'm not really a long way from reality, and hence, how much oil and gas is there in Poland? I'm expecting it to be less here proportionately than Poland, and that was the exercise I was undertaking.
And can you show me on these maps what in your benchmarking is on the Magura Nap? Because I'm not sure I understand this.
Yeah, I think can you see the pink polygon and the blue polygon at the top,
Yes.
where you've just got blue polygon and no pink polygon? That's probably largely Magura Nap.
Yeah.
Okay.
And so, if I may, just one more thing, to come back to the question that was
I'm
raised earlier.
trying to look at the broken line, whatever it is.
Oh, that's national boundary.
Then it's a little bit difficult.
Yes, there you go. That area.
That I understood,
that's
yes.
Magura,
It's just
yeah.
that the Magura Nap, when
Yeah,
I look
yeah.
at the map on the left, seems to be further up.
Oh yes, there we've got it on there, haven't we? That's yeah. So there's a bit in that corner where the blue is present and the pink isn't. That it's a Magura, a bit of Silesian as well. That it comes back in, doesn't it? Yeah.
So there's not much Magura Nap, or do I
Well,
understand?
And that is the one of the points. And to come back to your question, there's just not as much data. There's a few oil fields there, but as I tried to show in my presentation earlier, that you move south, it gets hilly, it's wooded, there's just been less oil and gas exploration. So there are fewer oil fields. So I think our database of oil fields, just using that, I think I also showed Dr. Long's graph, even with my changed area, it's still quite a modest amount of oil per square kilometre. But it's based on a small amount of data, as is my orange bar. It was based on 3 fields, that orange bar on that graph. So, if one of them didn't succeed, it would be 2/3 the height. If 2 of them didn't succeed, it would be 1/3 of the height.
Apologies.
No problem. I have no further questions, Madam President.
Questions?
Yeah.
Mr. Newey?
Yes. Mr. Atkinson, you were discussing earlier, there was a discussion about whether there had been any reinterpretation of data after Discovery purchased AOG. Do you recall that?
Yes.
And you referred to it as having been reprocessed.
Yes.
For the record, that was at transcript 1615. Can you explain what you mean? What's the difference between reprocessed or reinterpreted?
Oh, okay. Yes, certainly. So seismic data is acquired in the field and it's tapes, digital tapes of data, and it is a big process to take that raw data and create the images we'll be looking at, those seismic sections. There's quite a bit of seismic processing goes on. So that is done. It gives you a seismic section. You can look at that, interpret the horizon, do what you do. So that's an interpretation exercise. Quite often you go back to the raw data that's been acquired, those tapes of digital tapes of data, and you have another go at processing it to try and make a better image of the subsurface. And then you can interpret that. That'd be a reinterpretation of the reprocessed data.
Thank you.
Is that, yeah?
And you mentioned when you were discussing the quality of the seismic, you mentioned, and again for the record, this is transcript 1653, there was a question as to whether data was acquired in the right way and processed in the right way. So bearing in mind how you've just explained the difference, does the way that something is processed affect how useful that data is?
That is, yes, if the seismic data has been processed poorly, it will be hard to interpret. If it's been processed well, it will be easier to interpret.
Thank you. Could we please now turn to, oh, sorry, I've now lost the page in a moment.
Who did, you mentioned reprocessing of the data. Who did reprocessing in this case?
I think, and someone maybe correct me, but I think the last
not allowed.
Oh, no, I'm pretty certain that the last phase of processing was done by a company based in Aberdeen called Seismic Image Processing Limited, SIP, and I definitely recall seeing some seismic processing reports from them, and I think you know, if they are a well-established company.
When would that have been done? Do you recall? And on whose behalf?
It was
getting it?
so I believe for the claimant. I think it was either 2012 maybe. I would have to probably refer to my notes and find the answer, but I think around about 2012. There was processing going on as late as 2014. So I've heard anecdotally. Sorry, I think actually my colleague has Colin Howard has a timeline which he's created as an exhibit.
My mic's not working, so I'm going to.
Microphone's on maximum, so if you want.
I'm going to speak loudly. I'll try.
Turn off one microphone. It's done.
Thanks. I don't mean to be obtuse, but I will ask this question as neutrally as I can. Have processing or reprocessing techniques advanced over time? I don't know if it's a function of computer power or not.
No, they have, but I think possibly more significant. This is very
Computing power,
fairly straightforward 2D seismic processing.
Right.
Computing power comes into play with 3D data when you've got
Right.
fast volumes, but this is 2D data, so it's a little different. Actually, what probably the most significant thing is experience. So the first guys who acquired the data would have processed it, come up with the results. Then every succeeding person who will have built on that and done some slightly better job based on what the previous people did. So it's an evolutionary thing. It's probably more of a human thing than a computer thing, to be honest, with 2D seismic.
So when Mr. Tushingham asked you, does the way the data is processed affect how useful that data is? What you're saying is it depends on who is doing the interpretation or the processing of the data.
Both of those things, yes. So you'd like to think
not the manner in which the techniques used, or is it all? It's all a question of know-how, is what you're saying.
I think so, yes. And in the report, I think I might have written it somewhere or I read it that actually each succeeding seismic acquisition in the field improved. So there was there's a mixture of companies, a Hungarian company, a Polish company, maybe a Slovakian company. They acquired the first data that was, and then next guys came along and acquired some more data than the previous lot and changed the way they acquired.
I see.
So it's an evolutionary thing.
Thank you. Back to you, Mr. Tushingham.
Mr.
Oh, Mr. Tony, pardon me. Excuse me, sir.
No,
I didn't
no
see who
problem.
was talking.
That's okay.
Yes, sir. Pardon me.
Mr. Atkinson, you were taken earlier to footnote 107 in your second report. If we could please have that on the screen, it's at page 45.
So that page again, please.
Page 45.
Second.
You have that?
I do, thank you.
This says, I also note that a 2009 CPR produced by Gaffney Klein Associates for a previous operator of the claimant's license estimated a gross gas resource, et cetera, et cetera, et cetera. And at the end, you'll see it says CH065 and a date.
Ah, yes, yeah.
Is that a reference to one of your exhibits?
Ah, yes, that's to one of my colleagues' exhibits.
Okay, that's what to indeed, Mr. Howard.
Yeah.
Can we please pull up CH065? Is this the document that you were referring to, that you had seen that referred to the Gaffney Klein and Associates?
Right, okay. That looks familiar, yes, there. Yep, it's coming back to me now.
Thank you. You were also asked some questions about the geological chance of success in the RPS competent persons report that were referred to in Dr. Longman's report. Do you recall that?
I do.
And do you recall that you said that you believed Dr. Longman had misread the document and that the true chance of success was higher? Do you recall that?
That's correct, yes.
Can I ask for exhibit CDL008 to be pulled up, please? This is the RPS competent persons report, isn't it?
That's correct, yep.
Could I ask for us to turn to PDF page 92, please, internal page 84. Is this the document that you were referring to?
Yes, that's correct.
Would you like to explain your position?
Yes, so looking at the top table, the Suvorov B prospect, the RPS evaluated that a well drilled on that prospect as having 1, 2, 3, 4, 5 sands in it. On the left hand side, Paleocene, Eocene, etc., etc. So each one of those sands individually, they give a chance of success of finding, as high as 13 and as low as 6. It's a slightly complicated way of doing it, but if you have 5 bites of the cherry, you're increasing your chance of finding one of those sands. So all told, even though one sand has a 13%, another one has 9, has 6, overall, the chance of finding a sand with a well at that location, just one, is 30%. So that is a stochastic total given at least one success. And on the right-hand column, G pos of 30. It's a complicated bit of statistics, but so that prospect itself has a 30% chance of success, not a 6% chance of success. We had conversations amongst the team about whether we should do this, and because it's rather complicated, difficult to communicate, difficult to implement, we made a simplifying assumption that we'd find a single sand in a success case and the thickness would vary, which made it easier to estimate a chance of success, which was, I think, I did compare it with Suvorov B. Mine, it's not dissimilar to my chance of success on a similar prospect. And I think the same is true for Suvorov A.
Thank you. I have no further questions.
Thank you.
One general question, sir, about something you said earlier. Yes, microphone. One general question about something you said near the outset of your, I think in your presentation, or maybe later on in your examination. The concept of this not being a quote seismic led exploration area. I think I understand, and I think that this wasn't seismic led by virtue of the geology and by virtue of the fact that there just wasn't much seismic data available. Could you just expand briefly or explain briefly what you mean by seismic led exploration? Is that a critique or is that just an observation?
Just an observation. The opposing expert and myself, we work in parts of the world where where we have lots of seismic and everything's very seismic focused. I spend most of my time on my day interpreting seismic data. Occasionally working in an onshore environment like this, and the data's poorer quality, there's less of it. This is a bit of an extreme. I have worked in areas in Kurdistan, in northern Iraq, where there was no seismic, and I had to come up with I authored a competent persons report on a thing called Sangor North, which is a Sterling Energy.
Stop there. No seismic because nobody bothered, or because seismic wouldn't have revealed anything.
They hadn't got around to it yet. There's just a hill, just like those ones in the Silesian Nap. When you look at the map, and there's a hill, and you can just work out that that hill means under the ground there's a structure which you might be able to drill and find oil. So I had to try and come up with prospective resources on the basis of the hill. We're staged further on from that. We're still very frontier. We've got a 25, I think it is, seismic line, so we're better off than I was in Iraq. The next stage, and I think, as I understand it, try and drill a well, find some oil, make some, get some, build on that, and when you've got enough confidence, probably ability to borrow money, I suppose, spend some more money on seismic and define the prospects better. So I should probably qualify what I said. It's right on the cusp. A lot of these prospects exist because there's seismic there, but they're not completely described by seismic. It's right on the cusp between having no seismic and having a reasonable amount. It's up in the middle. I think I created one prospect, which is, it had one seismic line on it, but mainly I created it because of the surface geology map told me there's a fold underneath, and therefore I could expect to drill there and find some structures. I think there probably was at least one seismic line.
Thank you.
If I understand way of how that is why I never switch it off. Yes. But if I take a big picture view, I understand what you have done is looked at the volumes, at estimates of volumes in place and geological chances of extracting these volumes. Is that what it is?
Yeah, the geological chance of success. Let me just explain what that is. It's if we drilled a well on a prospect, what is the chance of encountering oil or gas which you could would flow to surface, and you think, yes, I could, if there's enough down there, I could probably make a successful oil or gas field here. The one thing it doesn't do, it doesn't say how much is down there. It just says that I found some, I don't know how much, just some, which is capable of flowing up to surface. And so that says I've made a discovery, and then you drill a few more wells and you hope that you're on the curve and that you found a lot of oil, and maybe you found a small amount. So I would call that success. I'm a technical person. It's a technical success.
But it's not necessarily a commercial success.
Yeah, it requires.
Yeah. And that is what your colleagues reviewed.
Yeah.
So you have calculated the volume of resources, where the level of resources, we're not speaking about reserves, right?
I shan't pick you up on the picky terminology, but I think you're right. Just all that's in the ground, not the amount of oil that will eventually end up on surface. Yeah.
And this oil that not is in the ground, that may be in the ground. It's a potential,
That is absolutely correct, yes.
potentially available oil.
Yeah, it's very early stage and it's exploration, so we haven't proven it all yet, so it's what we.
And
expect to
to be sure whether oil is in the ground, you must drill.
That's correct.
And you work with probabilities and you do the P90, P50, P10 probabilities. Is that right?
That's correct. Actually, my job is really to capture the range because it's very difficult to say how much there is actually there. So if you capture you say how little there could be and how much there could be, and then in the middle is the best estimate.
But still, you're not sure that there is oil. It's
That-
not only a matter of quantity, it's a matter of principle, of fact.
That's right.
Is that right?
That's correct. So in terms that you're describing it, if I say there's a 20% chance of success, there's a 20% chance of success of there being oil there.
But there could be one drop.
It could be just a little bit, a little drop, and that you're at the start of the curve. There could be very little, and then it could be quite a lot, or maybe really a lot. So, but you just get onto that range of volumes. That's
Right.
where the
Thank
chance of
you.
success.
Just wanted to be sure that I have had understood this correctly. Thanks. I have no other questions. So further questions? So that leads us to the end of your examination. Thank you very much, Mr. Atkins.
Thank you, Madam President. Thank you.
So looking forward to continuation tomorrow, we will hear Mr. Moy and Mr. Howard. Is that right?
That's correct.
And Mr. Longman and Mr. Duarte Silva and Ackman, most likely Wednesday morning, or how is this? I'm first looking at you because you're, no, I need to look at you because you're first doing the cross examinations.
Right. So I think that I think that we could be done with Dr. Moy and Mr. Howard in the morning.
And then we take Mr. Long afternoon,
Yes.
and that can certainly be completed.
Yes, that I intend to complete. If it works that way, I intend to complete Dr. Longman tomorrow.
So we would have for Wednesday morning left Mr. Duarte Silva and Ackman, I mean, together.
Correct.
Does this sound like a reasonable plan?
Reasonable to me, yeah.
Good. Is there anything that we need to discuss? As we said, tomorrow at the end of the day, we will give you some either questions or indications of topics that we were more interested in your addressing on Wednesday afternoon.
Thank you, Madam President.
I'm looking at my colleagues. Yes.
Yeah, afterward.
Can we start earlier tomorrow at 9 o'clock, or is this a difficulty?
I think that's fine with us.
That's fine with you.
Yes, that's fine with us.
You look happy.
No, I was just checking. I was just checking with Dr. Moy that he would be available. That was all.
Yeah, it's better he's there. Yeah, good.
That's fine.
Then let's start at 9 tomorrow morning.
And Madam President, if I might just inquire or just confirm what the tribunal's plans are with respect to Wednesday. My recollection is that the tribunal stated it did not wish to have closing arguments, but instead that there would be sort of an hour or so, understanding the timing's flexible of question and answers with the parties.
What we have in mind is that tomorrow before we close for the day, we will give you a few indications of what we would like to hear on Wednesday. For instance, we would say, I don't know, we have not heard much about Krivolka, for instance. And then can you please emphasize this rather than Smilno, which has been discussed a lot. I'm not saying this now, I'm just, this may be a possibility, or they may be a particular legal issue that we would like to hear more about. And then we have questions on the spot as well, of course.
Okay.
But the idea is more to give you some indication, and then you have an hour to wrap up whatever I think is important to say. Of course, you would tell us.
Do you think they should expect questions from the tribunal during the wrap up? Or is this more of a pleading?
No,
Mr. Ranway was asking.
it will essentially be a pleading that can be interrupted by questions because, yeah, that may well happen. So I'm not to say it like.
Well, I certainly expected the questions. I guess what I was trying to ascertain, and we had some discussion earlier today about this too. I don't want to speak for both parties, but I think this is very helpful. Whether we should be preparing a presentation as such tonight, but it sounds like we should be waiting to hear what your concerns are first tomorrow.
I think, yeah, it might be a little premature to
Yeah.
prepare something tonight because it may be besides what we are really interested in.
Yeah.
So if you can reserve the presentation for tomorrow, the preparation for.
And that's what we
tomorrow
had been
night, it
planning
would
on.
be more, would make more sense. Yes.
But who are we asking to spend all night tomorrow preparing the 100?
Well, no, that was what I was just going to
All right.
ask. I think certainly, sorry, Professor Sands.
And you. So yeah. And it may be there are very few questions.
Yeah.
You know, it may be this very short.
Yeah.
I think I'm speaking for myself here, but I may speak for Mr. Newing. Well, we are unlikely, I think, to be able to pull together another slide presentation, but we will certainly have a comprehensive set of answers to questions. But if you would very much prefer a slide presentation, then we will do our best. I'm just wondering what the tribunal's preference would be.
I mean, there's ways of being convincing even without slides.
I quite agree.
As if you look at people who tell them something, it may be more effective than having 100 slides.
Yeah.
So we're not expecting slides.
That's very
If you- I mean, we're not prohibiting slides.
Yeah.
Unless you want to read between the two of you, but we're not really expecting slides.
That's very helpful. Thank you.
It's more, you can explain a few things and we may then add additional questions if we have any.
Perfect.
Is that sufficient clarification?
That's
Very helpful and consistent with what I think the tribunal had originally told us.
I should say we're sensitive too to the fact, I'm always sensitive to the fact that it's somehow oddly easier living out of a suitcase in a war room than it is for people who are in their own cities with other obligations close at hand to be working through the night. So I just mentioned that for myself.
Good.
Since
So-
neither of these, following on from my friends, since neither of these sides have appeared before me before, the people who have will know that I am constitutionally opposed to slides.
Now you tell them.
I want advocacy. Slides are a complete distraction
I
to
would-
advocacy.
Then we apologize for our opening statement.
No,
It's my personal view.
I would beg to differ in the sense that there are slides that are helpful. It all depends how you do that. That allows us now to close for tonight and we discuss slides later on. See you tomorrow, 9 o'clock.
Thank you.